Remember, we kind of went out of line a little bit yesterday, so we could look at that qualifying a buyer math. So now we need to get back to where we were. And obviously when we get to qualifying a buyer, we can just skip right over that section because we've already covered it. So before we did that, we were in the throes of talking about our buyer agency agreement. And first off, remember, look for your keywords, not just, for your exams, but for life too. If you have an exclusive buyer agency agreement, is that an oral agreement? And I see head shaking no. Why is it not oral?
Can't have an exclusive buyer agency agreement orally. It's got to be in writing.
There you go. So whenever you see or hear exclusive buyer agency, it has to be in writing. You cannot demand exclusivity in an oral agency agreement. You cannot bind the buyer for a certain amount of time in an oral agency agreement. So if you demand exclusivity, or if you put in a time limit, like we're going to work together for 2 months, then we have to put it in writing. Do you have any questions or comments on that? So what we're looking at is our exclusive buyer agency agreement. And again, where we were last, let's see what we were talking about last. Compensation of the firm. So remember, our agency agreements are employment contracts. And I think the common misconception that new agents have, we know we get paid from the seller, right? The MLS, the listing advertises how much they're going to pay us. But please don't forget that we have to discuss commission, bless you, in our buyer's agency agreement as well. Because what if the seller's not going to pay us? If we don't discuss it with the buyer and the for sale by owner says, no, I'm not going to pay you, there's nobody else left. So be very careful about marketing your student. Y'all don't do that. Don't run around saying my services are free. I think it downgrades us, first off. What's it say about that, us as an industry? But second, when you get that buyer that goes after the for sale by owner, you may have to say, oh yeah, by the way, if the FSBO is not going to pay me, you have to. The other place, what if it is advertised in MLS? But the listing in MLS, y'all remember me talking about this, is offering you a 0.5% commission. Are you going to be satisfied with that? I sure hope not. So just because the commission you're being offered, just because you are being offered commission MLS, doesn't mean it's what your firm expects to collect. So in this case, if my buyers had moved forward, I would have collected my 0.5% G from the seller, but I would have collected the rest from my buyers. And that's a conversation I had with them before I went to show the property. So make sure, y'all, nobody's going to watch your money like you. So y'all watch out after your money. Make sure you are. Any questions about compensation from the buyers? Let's see, there's a provision, other potential buyers. Buyer understands that other prospective purchasers represented by the firm may seek property, submit offers, and contract to purchase through the firm, including the same or similar property as buyer seeks to purchase. Buyer acknowledges and understands and consents to representation of other prospective purchasers of firms through its agents. Exclusivity is a one-way street. The buyer can only date one firm. The firm can date as many buyers as they want to. And you very well may have yourself in a situation where you're working with 2 buyers and they're both interested in 123 Main Street. So now you have a duty to present 2 offers on 2 buyers' behalves. And when it comes to that, guys, remember, I provide the facts, they make the decision. So I'm going to do a CMA for both, and I'm going to discuss with both. They need to come up with how much they're comfortable offering. They need to come up with how much due diligence they're comfortable, earnest money. They need to come up with their own terms. I can advise, but I can't share the information, right? I can't say, well, I have a buyer getting ready to get an offer for this amount, right? I can't disclose the terms of an offer without the offeror's permission. I can't pit the 2 together, right? And I certainly can't tell them what to do. And I think if you're ever in that situation, anytime you're working with a buyer, especially in this market, help them determine their risk tolerance. How much due diligence are you comfortable losing if we have to terminate? How much over asking price are you comfortable going? So if you find yourself in a situation, two buyers interested in the same property, just proceed with caution. Make sure you're treating both honestly and fairly, and you're representing both the same. Questions on that? That's one thing I've learned. One buyer may say, I'm not offering more than 5,000 due diligence. And your other buyer may say, I'm going to throw down 25, right? They're all different. That's why I'm not telling them what to do. I'm providing the facts for them to make the decision. As we mentioned, our agency agreements are bilateral contracts. And in all of our agency agreements, each party has to list their duties and responsibilities. So we'll see the buyer's duties to the firm in just a second, but our firm's duties to the buyer. During the term of this agreement, firms shall promote the interest of the buyer by, and then we're going to rattle off things we're going to do to promote the interest of our buyer. We're going to perform the terms of this agreement. We're going to seek property at a price and terms acceptable to the buyer. We're going to present offers in a timely manner or counter offers to and from the buyer. We're going to disclose to the buyer all material facts relating to the property or concerning the transaction in which the firm has actual knowledge. Accounting for in a timely manner all money and property received and with the buyer may or may not have an interest. Unless otherwise provided by law or buyer consents in writing to the release of this information, firms shall maintain the confidentiality of all personal and financial information and other matters identified as confidential by the buyer if that information is received from the buyer during the brokerage relationship. In satisfying these duties, firms shall exercise ordinary care, comply with all applicable laws and regulations, and treat all prospective sellers honestly and not knowingly give them false information. In addition, firm may show the same property to other buyers, represent other buyers, represent sellers relative to other properties, or provide assistance to a seller or prospective seller by performing minimum acts that are not inconsistent with the firm's duties. So we once again remind the buyer, firms probably working with other buyers, may even have multiple buyers interested in the same property, but we're also spelling out our duties. What is my job? What do I owe you? I'm going to help you find a property. I'm going to help you present, negotiate your offer. I'm going to help you to get to closing. I'm going to safeguard your money. So I'm telling the buyer, this is what we're going to do for them. Upon closing of any sale not entered into a listing service, buyer authorizes firm to submit pertinent information concerning the property, including sales prices, such services. This might be a case if your buyer's going after for sale by owner. The FSBO is not an MLS, but when we close, we may want to enter it in MLS for comp purposes. So we can pull comps on it later, so the appraiser can as well. Again, check with your firm on that. They may have a policy. So the firm's duties to the buyer. Disclosure of buyer's name and mailing address. Unless otherwise stated below, firm has permission to disclose buyer's name. In accordance with this general statute, if a dispute regarding the return or forfeiture of any earnest money deposit arises between buyer and seller of the real property, buyer may agree to purchase. The escrow agent holding the deposit may deposit the disputed monies with appropriate clerk of courts. So we saw something similar to that in the listing agreement. If we go under contract and then we terminate, the parties have to release the earnest money. It doesn't just happen automatically. And if the release of the earnest money is in dispute, the escrow agent can't release it. So they just hang on to it until we resolve. If after a certain amount of time it's not resolved, then they can turn it over to the clerk of courts and let the two go hash it out in front of a judge. Let me go back to this one real quick. Buyer's permission to disclose buyer's name. What if you're working with somebody famous? what if you're maybe working, let's see, around here, we have, some local news anchors that, when we all see Van Denton out, we know it's Van Denton, for example. What if you're working with, I used to use the example of Cam Newton, but he's not doing much for me anymore. So I need another. But what if Cam wanted to buy a townhouse in Winston-Salem? When I present the offer with the buyer's name as Cam Newton, what's the seller see?
Dollar
Money,
sign.
money, money, right? And they're gonna counter because they're like, this is Cam, he can afford it. This is Van Dent, he can afford it. So there may be a time that we need to safeguard our buyer's name. Again, your firm may have policies on that. Some firms will have submit the offer my name on behalf of the buyer, for example. That might be one way to do it. Once we go under contract, then we can say you just contracted with Cam Newton. But we may have times that we need to safeguard our buyer's name to not give away their negotiating power. So know who you're working with.
That's a little just in my thinking. Again, commission rules are the rules, but that just seems a little isn't it? Well, never mind. Because it's not protected. I was saying, because I'm supposed to present the offer, right? I'm supposed to hand the offer to my client. So how do I do that without revealing the names?
And that may be a concern that the seller has, right? So that may be something that the seller may, and it may be if the buyer's agent says, look, this is my buyer chooses to remain anonymous. I don't have to say my buyer, somebody famous that right? I might as well give you the name if I'm going to tell you that. Okay. So you might just have to say my buyer chooses to remain anonymous. And then the seller has to make a decision with that. So that might hurt. That's a good point. That might hurt their negotiating power as well, right? So it's up to the buyer how they feel comfortable with that, how they want to proceed with that. I mean, maybe Cam can call his attorney and come up with a pseudonym or something that we can present the offer with. Maybe offer it in the form of his company or something, right? Whatever his LLC is. So maybe, but I guess my point is I just wanted you guys to kind of be aware. If you do ever get the opportunity, it's a discussion we absolutely need to have with that well-known buyer on how to present and how they're comfortable. I would love to hear if you guys ever get to work with. I'm serious. I haven't had that opportunity. Van Denton hadn't called me yet, but I would love, he's got to buy and sell houses at some point too, right? So I would love to have that opportunity. So yeah, y'all call me, make a note to call me. Tell me how you handled that. That would be a lot of fun. We're here in the Triad, we don't have many celebrities hanging around, right? But you get down into maybe even to Charlotte and Raleigh, you might more encounter Wilmington, that kind of area, second homes,
We got a lot of NASCAR.
There you go. You got a lot of NASCAR around here. Absolutely. That's a great point, Donna. And somebody like me that isn't familiar with NASCAR, you could turn a name into me and I'd be like, okay, so just because they're a NASCAR driver doesn't mean everybody knows them, Here's our anti-discrimination clause. We saw this in the listing agreement. Here's our red warning about the love letters. Again, we saw this in the listing agreement. And then we look at the buyer's duties to the firm. Buyer agrees to cooperate with the firm in the acquisition of a real property on the type described in paragraph 1, including but not limiting to. The buyer agrees to work exclusively with the firm during the term of this agreement. Immediately refer to the firm information about any properties buyer may have an interest in examining. Complying with the reasonable requests of firm to supply and pertinent financial or personal data needed to fulfill the terms. Being available for reasonable periods of time to examine properties. Examine properties only by appointments made through the firm or accompanied by an agent of the firm. Conducting all negotiations and communications through the firm. Conducting all due diligence on the property in consultation with the firm. And paying for all products and services required in examination and evaluation. I really wish our form would take this a step further and say, even if the property doesn't close, because your buyer needs to understand that if they have had the home inspection done and then they terminate, they still owe the home inspector for the service performed. Everybody with me? So when your buyer starts thinking about terminating, it might be good for us to remind them what has been done. This is the money you're going to owe. So have that conversations with them. Buyer being available for reasonable periods of time. Buyers have work schedules. This is why sometimes our schedules need to be more flexible. You know, not all buyers work Monday through Friday, 9 to 5, right? Sometimes those buyers that do work Monday through Friday, 9 to 5 need to view property in the evenings or the weekends. I'm not saying we can't set our hours, but I'm just suggesting you guys be flexible. If you have a buyer, if you refuse to work on the weekends and you meet a buyer that can only see property on the weekends, you're not going to be able to work with that buyer. You guys with me? So if we can stay flexible, that it might open our pool of buyers up a little bit. I've worked with 2 buyers now that have worked 3rd shift. So I'm meeting them to either see property when they get off work at 8:30 in the morning, or I'm meeting them before they go to work at 6 o'clock at night, right? Because they're sleeping during the day. And I'm respecting the fact that they're sleeping during the day. So sometimes we just got to be flexible. Other professional advice, again, we saw this with the listing agreement, but when it comes to recommending services, I think we're more apt to recommend services when working with buyers than we are working with sellers. Sellers just don't need as many services as buyers do. Now, obviously, if the seller says, yeah, I want to have a pre-home inspection done before we list, can you recommend anybody? You know, that might be an example, but the buyer's probably looking towards us for recommendations for home inspector, pest inspector, surveyor, well water test, radon test, who else? Everybody involved in that due diligence period. Guys, always give your buyers choices. Say something like, here are the name of 2 or 3 home inspectors that I've worked with in the past, or here are the name of 3 home inspectors that my firm has worked with. If you're brand new and you don't know home inspectors yet, you'll get to know some, but your firm probably has a preferred vendor list that can help get you started, and you'll form relationships with home inspectors and the people through the process. Never, ever, ever look at a buyer and say, this is the home inspector we're going to use and you're going to like it. It's their home inspection. Don't send them to Google. My goodness, they can do that on their own, right? Why did they hire you? So try to come in, if not through you, then through your firm with some good recommendations. Always give them choices. Like I said, if we have time today, we're going to look at that professional services disclosure because I think that's a great form. Buyer acknowledges a receipt of a sample copy of the offer to purchase and contract, the Q&A brochure on home inspections, and here's our sample professional services disclosure and election. Again, if you don't provide these things to your buyers, then don't check these boxes. It makes sense, doesn't it? You only get to check these boxes if you provide your buyers with this information. Home warranty, the seller of any property may be interested, the buyer may be interested in buying, may or may not have a home warranty. If the seller does not provide home warranty, the buyer may elect to purchase one. Buyer understands that the firm will assist in identifying home warranty products. Buyer must refer specific questions regarding coverage to the product, to the person providing the product. And again, the firm with the home warranty, they break all RESPA rules. The firm may collect a referral fee for using their in-house home warranty company. So again, just get with your firm's policy on how much, how to complete that field. Maybe it's 0, maybe it's whatever amount. So just get with your firm, how they're going to handle that. We saw that in the listing agreement as well. Confidentiality of offers. Brokers are prohibited by the Real Estate Commission for disclosing the price or other material terms contained in a party's offer to purchase, sale, lease, or rent without express authority of the party making the offer. However, sellers may not elect to treat the existence or terms of any offer the buyer makes as confidential. Sellers may elect not to disclose or authorize sellers' agents to disclose. You and I have to follow license law and commission rule. The seller doesn't. So yet so many good reasons not to let the buyer and seller talk directly. Just because we can't disclose the terms of an offer. If the seller gets their hands on the right buyer, that doesn't mean that they can't. So be the communication for them. But I think this is important too. Again, back to the scenario where you have two buyers interested in one property. I can't look at buyer A and say, this is how much buyer B is offering, and then go back to buyer B and say this, right? I can't pit the two against each other. I cannot disclose the terms of an offer without the offeror's permission. Additional provisions, again, just anything you can agree to. Plumber, we were talking about this yesterday. You said you had a property in Wake County. Maybe you can even throw in here something that says, or around an airport, you know, so if that's something you can add to, you know, get you to closer to Greensboro, you know what I'm saying? So you could use that possibly to, as long as you guys, if you make a change, just have everybody initial and date it, but that might be another way for you to handle that.
Yes, ma'am.
Dual agency, again, we'll come back to this. We'll look at dual agency in just a bit when we talk about dual agency. But as we saw with the listing agreement, the buyer has two choices. They either authorize the firm to act as a dual agent, or they want exclusive representation and does not authorize the firm to act as a dual agent. So the buyer has to initial one or the other. Yes to dual or no to dual. And if they say yes to dual, then we can offer them designated. Is everybody good with that? If they say no to dual, designate is not an option. In order for us to have designated, we first have to have a yes to dual. And if they say no to dual and you say, well, let me tell you about designated, then we can get them to change their mind because of designated, right? So we can take that angle as well. Again, we'll talk about dual and designated in just a bit. Dual agency compensation. If the firm acts as a dual agent, including designated, the total fee that the firm expects to receive for its services in representing the buyer and the seller shall be. So some firms have a policy that maybe they charge less if in a dual agency situation, maybe they pay their agents more. So if it's anything different, or if you're in a dual agency situation, what does the firm expect to collect? So again, having this conversation with your firm and understanding the firm's policy. So we talked about compensation of the firm earlier in the buyer agency agreement, but now we're specifically talking about what happens if we get, how much do we expect to be compensated if we get put in a dual agency situation? We're once again told to insert a dollar amount, percentage of purchase price, or other method for determining. Don't put zero in here. This will in no way affect or modify the amount of the fee set forth paragraph 4 that we talked about. The firm expects to receive for its services in representing buyer under this agreement. If the buyer is interested in purchasing a property where the firm's total fee is different than described here, the firm shall timely disclose the fee to the buyer and confirm it in writing before buyer makes or accepts an offer. So again, firm's policy. You guys affiliate with your firms. You probably have some kind of new agent orientation. Do they sit down and go through the forms with you? Probably similar to what we're doing. And probably if they have a special way, a specific way, they want you to complete this, how they expect to be compensated. Mediation. Again, best if we have a problem, hash it out in mediation instead of going full-blown court, if at all possible. Once again, this is an entire agreement, so we can't piecemeal it, right? The whole exclusive buyer agency agreement is one. That's what we're saying here. Surveillance. Remember we said the seller can have video. They cannot have audio. However, just in case, have this conversation with your buyers. And that's what this paragraph is addressing. It's letting the buyers know that video surveillance without consent is not illegal, but the seller should not have or audio. With that being said, just make sure your buyers know that not all sellers are good, honest people, are they? So caution them about what they say in the house. I'm not worried about them giving their opinion about the tacky paint color. I'm worried about them hurting their negotiation power. So wait till you get away from the front porch, away from the Ring doorbell, before you have a serious conversation. Unless a property owners notify the public that photography and recording is not prohibited, it is permissible to photograph or video the interior of a private property, since the owner's permission to enter the property implies permission to do so. However, under no circumstances may buyer take pictures or video that intrude on a property owner's reasonable expectation of privacy. Again, so when you're with your buyer in the house, make sure they're just taking pictures of the space, the stuff that's going to convey, and not the stuff, right? They don't need to be taking pictures of the desk, or, you know, the important documents in the desk, right? That's where, when you're a buyer's agent, when you're walking through a home with a buyer, stay with your buyer. Don't just let them run amok in the house. Let's all go from room to room together. Buyers should only photograph or video things that are in plain view. For example, a photo or video of the contents of the medicine cabinet or the financial records would be impermissible. It even spells it out for us. In addition, any permitted photography or video should be used only in a manner related to the buyer's examination. Taking impermissible pictures or video, using them for impermissible purposes, could subject buyer to civil liability. So they can't take these pictures from touring the property today and slap them all over social media, right? It's not their home to promote and advertise. So just be mindful. They're taking pictures for themselves to decide if how they want to purchase the property, if they want to purchase the property or not. Buyer understands that neither the firm nor its agents have control over information about any property buyer may purchase that has been placed on the internet in connection with the marketing, whether through a listing service or otherwise, including but not limited to photos and any other information that will not be removed following buyer's purchase of such property. It takes a while for a listing to come down. So when your buyer closes, they may still be able to find it for sale on Zillow, for example. So just have them give it time. Eventually it will come down. And again, this is another conversation. I have no control over Zillow. I only have control over MLS. It just takes a while for the feed. Y'all, I'm not kidding when I say there are thousands of websites that have homes listed for sale. So it takes a while for those sites to catch up when we mark the status as closed. And the pictures may never go away. You guys ever found an old listing in Zillow that's not even on the market, but you can still see pictures? So here's our wire fraud warning to buyers. We talked about this yesterday with sellers. Again, just no email wire transfer instructions. That's the simplest thing we can say here. No email wire transfer instructions. And then we have a places before for two buyers to sign. So there's the first buyer with their name and signature, contact information, and mailing address. And then a second buyer. If you have more than two buyers, we use our additional signatures addendum. Make sure we get all buyers that are going to show up on the deed or the loan and their spouses need to be on the buyer's agency agreement. Have everybody on board from day one. If your buyer is an entity or Cam Newton with his company, then you could do your entity buyer here. Maybe Cam's assistant can sign on his behalf or something. So you could put your entity buyer here, whatever that corporation name is, contact information and mailing address. And then the last page is for us. So firm, real estate name, license number, office address. And remember, we are signing on behalf of the firm. The firm doesn't actually sign this. The broker in charge doesn't sign this. We as the individual agent are allowed to sign on behalf of the firm. And don't forget to always, always, always include your license number. So that's our buyer's agency, excuse me, our exclusive buyer agency agreement. Any questions on that? Also in Learn Test Pass, you got your exclusive buyer agency agreement, which is 201. You got your guidelines for completing the exclusive buyer agency agreement. So remember to use these as a resources. By the way, if you're a numbers person, the 100 series are usually seller forms. 200 series are usually buyer forms. So if you're a number person, you're not sure where to find stuff, again, just sometimes having an idea of what the number is, because we may think we know the name of the form, but if you don't know the name of the form, then you cannot going to be able to search it. The other form that we have, we're not going to spend as much time on this one, just pointed out. This is a non-exclusive buyer agency agreement. Non-exclusive meaning what? The buyer can date how many firms? As many as they want. We're pretty much putting oral agency in writing, right? We're not committing them to exclusivity, but we're pretty much just putting oral in writing. The purpose of this form is to properly establish a written buyer agency relationship. The various forms of agency relationship are discussed in our working with real estate agent disclosure, a copy of which the buyer has received and reviewed with the agent. Buyer's execution of this form that confirms that buyer has read and understood the contents of the brochure and is making a decision to request buyer agency for the period of time set forth below. Buyer represents that as of this commencement date, buyer is not in a party to an exclusive buyer representation agreement with another firm. So you could have a buyer with several non-exclusive buyer agency agreements, but the buyer can only have one exclusive buyer representation. And that's what that last sentence is saying. Again, firm's policy may dictate how and when and if you use this form. Some firms say no. We're either going to go oral or exclusive. We're not going to, do this. So again, if this opportunity comes up, but this might be another good way to get a hesitant buyer to sign something so we can present the offer. Maybe they're just so scared to sign. And you say, all right, look, I got to present this offer on your behalf. And in order for me to do this, we got to have something in writing. So if you don't want exclusivity, maybe if your firm allows, I can talk them into this. And at least this will protect your commission. It's better than nothing, right? And then we have something in writing that we can present the offer. So again, the property duration, it still has an expiration date. This discusses compensation of the firm, confidentiality of offers. Here's dual agency again. So it's pretty much, it's just an abbreviated exclusive, but it's non-exclusive. So again, check with your firm if you have that hesitant buyer. Buyers are sometimes like these scared little creatures that they get scared easy. So sometimes we have to approach them cautiously so they don't, run away. So this might be another option that we have.
Can this switch to like an exclusive buyer agreement if?
Yeah, we could. We would have to terminate this one, make sure, verify that they're not an exclusive buyer agency, and then create a new one. Yeah, we could, absolutely. Yeah, and again, the difference is this one's not exclusive, the other one is. So yeah, if they say, no, I'm not, and then tomorrow they change their mind, then we can, and then they're committed just to us.
I'm sorry, Julie, when you say terminate this one, what does that look like? I mean, like, is there something that you sign that says this is terminated?
We have termination of agency agreements, you bet.
Oh, okay.
Yep. We got forms for that.
Thank you.
So if you need, and it, I haven't seen, with thinking off the top of my head, but I want to say there's one termination agency agreement that you can terminate, non-exclusive buyer, exclusive buyer, right? You just check which box, which one you're terminating. Yep. Other questions or comments? So this is where we are. We talked about our different buyer agency agreements. And remember the guidelines for 201. I don't think 203 has guidelines. I think it's just 201 that has guidelines. We've talked about hesitant buyers, giving you a couple different options for hesitant buyers. Maybe we can limit the duration of the agreement. Maybe we just have an agency agreement for a day or a week. And if I get you under contract in a week, then I'm going to ask you to sign an extension just to get us through closing, right? Maybe we have to take small baby steps. But maybe we can limit, maybe you do an agency agreement for 1 day, 1 property. If I show you this one house today and you like it, I'm in. So I hope what you're hearing is that we have options when buyers are hesitant, buyers are reluctant. Guys, some buyers have been burnt by agents in the past. Not all agents practice properly with the buyer's best interest in mind. So some of them are hesitant just from past experience. And now we're tasked with the challenge of working harder to prove that we are good people too. We're just, our industry has some bad eggs, but doesn't every industry have some bad eggs? So it's just unfortunate that the buyer found that one. Like I said, we could also limit our agreement to just a specific property. So if the buyer's hesitant, we could always say, we'll just do an exclusive buyer agency agreement for 123 Main Street. If it works out, I'm your agent. If not, then hopefully you've continued to build their trust, build that relationship. So when they go look at 456 Elm Street, they'll call you, they'll ask you to help. So continue. We have to work harder sometimes with buyers to build their trust. So continue, just continue working at it. And then, like we said, if your firm allows, you might be able to enter into a non-exclusive buyer agency agreement. That might be another option as well. So there's options to a hesitant buyer. But guys, remember, switching from buyer's agent to seller sub-agent or seller sub-agent to buyer's agent should be the absolute last ditch effort. Only if you must. And make sure you document everything. Make sure you notify everybody of what's getting ready to happen if you have to make that switch. I think as we talked about yesterday, the commission doesn't not allow it. They just highly recommend that we don't. So, and if I were you, if you were going that route, I would prove that you have no other options. The buyer has said no to this, this, and this is all we got left. So just proceed with caution. Straight from the commission's mouth, a buyer's agent will be held to a higher standard under the common law with regard to protecting and servicing the buyer's interest than will the seller's agent dealing with the buyer as a third party. Remember, the fiduciary relationship with the buyer's agent is that with their buyer. The listing agent's fiduciary responsibility is with the seller, right? So who's your loyalty? Who gets old car? When you work with a buyer, once again, caveat emptor, buyer beware. The onus, the responsibility is on the buyer to learn everything that they possibly can about the property. And when the buyer hires an agent, we take on that responsibility with them. So we're assisting them, we're helping them, we're showing them property, helping them complete their offer negotiations, counter offers, helping them secure financing. I'm going to say the average first-time home buyer has no idea what all is involved. Home inspection, pest inspection, survey. So never assume that they know. Even if they've bought 5 homes before, never assume that they know. So when we're working with buyers, we're going to help educate the prospective buyer. Not just about our relationship, but about the various things that they should research. I've never had a buyer decline the home inspection. I did have a buyer once decline the pest inspection. I thought that was strange. I said, it's only like 65 bucks. Are you sure? She said, I said, you got a crawl space and, you know, I can't see the whole way back there. Are you sure? And she said, I'm going to call Terminix when I close. So I said, all right, I need you to initial here. You know, I got that in writing as fast as I could. But pretty much buyers are, I mean, again, I think it comes back to us and making sure that we're doing our job right. If we're explaining the importance of inspections and investigations to the buyer, letting them know that this is a as is purchase, letting them know that once they sign, there are no recourses. They sign accepting this property as it is. So having these buyer consultation appointments up front and helping to educate the buyer about the process, about what to expect, is still important. And I know it's tough in this market. This is a swift market, but that doesn't change the fact that we don't have a duty to help educate our buyers. We owe them that. Help the buyer determine their specific housing needs. I went to a conference once and one of the speakers said that when they're meeting with a buyer, they don't ask MLS input questions. So they don't ask the buyer, how many bedrooms do you want? How many bathrooms do you need? They don't ask the buyer those questions. The buyer can go to Zillow and find that out on their own, right? They ask the buyer, what do you plan on doing? What's everything you need to do in this home? Well, there's, you know, maybe mom and dad and 2 kids. So there's 3 bedrooms, but maybe now, I don't know, dad works from home. So now we need to find a 4th bedroom or an office, right? So not by specifically asking MLS input field questions, maybe asking other questions, we can help them identify better what their options may be, especially right now with low inventory. If they say I have to have a 4 bedroom, that might be tougher than finding, maybe I can find them a 4 bedroom, maybe I can find them a 3 bedroom with a bonus room or a 3 bedroom with an office, right? So trying to dig a little deeper, especially when we don't have a lot of inventory going around. Do they want a yard? How big of a yard? What do they want to do in their yard? If you want a playground and a trampoline and a pool, we got to find you a pretty big yard, right? So sometimes just by asking questions, having conversations. Have you guys worked with a buyer yet where I swear Mr. and Mrs. are not describing the same house? I swear to you, they're sitting there talking about 2 different houses. Have you guys met them yet? That's fun, because now we got to somehow get the 2 of them presumably under one roof, you know, get him what he wants and get her what she wants. So that's fun. Be prepared too for buyers' minds to change. Once they get out there and start looking at what they think they want, their mind may change. So just be prepared for that. I had several occasions of buyers saying, I absolutely do not want this. Okay, we go out and look at property, then call me a week later and say, I want to see 123 Main Street. Well, 123 Main Street has the one thing that you specifically told me you didn't want. You know, are you sure? Yeah. We were, all right. Y'all want to know what they end up buying? 123 Main Street. So just be prepared to step back and regroup if need be, especially in this market. I think buyers are starting to accept they may not be buying their forever home in this market. They may have to get what they can get. And then when this market stabilizes 3-5 years from now, maybe we can get them in their forever home. So maybe we're not looking for the perfect home today. We're just looking for something good enough, you know. And again, I think we can kind of help with our experience and just knowledge of the market, knowing what's going on out there right now. Crazy times in real estate. I mean, we had a guy buy, somebody from my team had a buyer buy, and I mean, he was pre-approved for like $400,000, but he couldn't find anything. So he ended up buying something for like 150. Well, he was a great candidate to the seller because obviously he was well within his means. He's like, I'm not living in this home forever. I'm just buying this thing for like 3 or 5 years. It's cheaper than renting for 3 or 5 years, you know, so I can sell this and then I can get into my $400,000 home. So I actually thought that was quite smart on his part. You can't find what you want, what's your next best? And that may be, it's not easy being a market right and being a buyer in this market right now. And those are reasons why. So we talked yesterday about qualifying a buyer, the math about qualifying a buyer. When you meet a buyer, when you sit down for that buyer consultation, we're all in agreement. The first thing you're going to do is you're working with real estate agents, because you know you're going to either they're going to touch on first substantial contact or you are. So, hi, welcome to my office. Glad you can join me. Let's sit down and do working with real estate agents. So once we do that, the very next conversation we need to have with the buyers is, have you talked to a lender? Y'all, we have got to stop showing property to unapproved buyers. We have got to stop that. We have created these monsters, these buyers out there that think, I'm going to find the house and then talk to the lender. You know, that's how we did it 15, 20 years ago, but it's a different time. And look at what 15, 20 years ago wound us up in the housing market crash. Is it because buyers weren't getting pre-approved? I don't know the answer to that, but just following my timeline, and it was about the housing market crash that sellers started insisting on seeing pre-approval or pre-qualification letters. Some sellers will still demand to see that before they approve the showing. Depends on the price point, depends on the seller. But to save us time and mileage and gas, we have got to have them speak to a lender, get qualified through a lender before we show them a property. There's a common misconception out there. People think, well, if this is what I pay for rent, then this is what my mortgage payment can be. And that's the furthest thing from the truth. So good for you. That's what you're paying for rent. Bravo. That means absolutely nothing in the for sale side of it, right? So don't let that fool them. Ideally, we want to refer them to, here's a list of 2 or 3 lenders that I've worked with in the past. I suggest you talk to one of them. Or here's a list of 2 or 3 lenders that somebody in my firm has worked with. Again, don't look at the buyer and say, this is the lender you're going to use. As we talked yesterday, though, with our qualifying the buyer math, that's what that was about. We should still also have the ability to help them. Again, if you have somebody who wants to see property today and your lender is off today, you may need to do a quick qualifying yourself just to make sure it's worth showing them that home today. I'll show you today, but the first thing tomorrow morning, I need you calling this lender. I'm not going to show you another one, but we can do a quick pre-approval or pre-qualification, at least to get them in the front door, have them talk to a lender right away. One thing the lender cares about is something called the loan to value ratio. The lender requires the appraisal. The appraiser works for the lender. The appraiser doesn't work for the buyer. The appraiser doesn't work for the seller. The appraiser works for the lender. Now, the lender lets the buyer pay for it. Isn't that nice? But the appraisal is for the lender. And what the lender is determining is this loan to value ratio. The lender will issue the loan on the appraised value or the purchase price, whichever one is less. This is why buyers are going in today with these appraisal, what are they called? Appraisal, not contingencies, appraisal.
Addendums.
Addendums, thank you. The appraisal addendums, basically saying, no matter what the appraisal says, I know I'm going into this over asking price. Buyers are acknowledging that they're going in after over asking price. It doesn't matter what this says. I'm willing to go X amount over the appraised value. If they stipulated amount, I've seen some of them that don't stipulate an amount. I'm willing to go in whatever amount need be over asking. Those appraisal addendums are not for the buyer. The buyer, through their due diligence, has the right to terminate if the appraisal comes back too high, right? And that doesn't change. I think these appraisal addendums are to make the seller feel good, to make the seller think that they're not going to lose the buyer when the home doesn't appraise. Does that make sense? It gives the seller the warm fuzzies. This does nothing different for the buyer. The buyer's just saying, yeah, I understand I'm going in over asking price and I'm willing to pay that difference. Because they know that the appraised value isn't going to be what their purchase price is, and they know their loan amount is going to be based off of the appraised value. So the lender will issue the loan amount on the appraised value or the purchase price, whichever one is less. The lender determines their loan to value ratio. They just take the loan amount, divide it by the value. Value is either the purchase price or the appraised value, whichever's less. So once you get that appraisal back, the lender knows what the buyer knows what their loan amount's going to be. And if they attach an appraisal addendum, then they got to come up with the difference out of their own pocket. Maybe, and I'm stressing the word maybe, they could get a loan for that difference, but the lender is going to probably not like that, are they? The lender's going to say, well, you want me to give you a loan, and now you want somebody else to give you a loan. So they would have to have approval. They would have to have permission. Most of these buyers that are coming up with the difference are coming out with it out of pocket somewhere, somehow. I don't know where this money is, but it's not at the Campbell household. Some of these buyers are amazing me with the numbers that you're putting down $100,000 in due diligence. Like, where are you getting that kind of money? That's what I want to know. The higher the loan to value ratio, the lower is the borrower's down payment, and the lower the riskier that borrower is to the lender. So let's just say, for example, our lender's loan to value ratio is 80%. And then let's say that you also have another buyer whose loan to value ratio is 60%. Which one is riskier to the lender? Which one is riskier? The 80%, right? Because that's more money coming out of the lender's pocket. And the 80%, the buyer's only putting down 20%. They're asking the lender to put down 80. Remember, this is through the eyes of the lender. So through the eyes of the lender, all right, I'll give you 80%, which means you're only coming up with 20%. So while your 20% is cute and all, who is the one actually bringing the money to the settlement table? It's the lender with their 80%, right? See why they have an interest in your property? Lenders get a bad rap, and I don't understand why. If you can't do 100% on your own, if you can only do 20, you're asking the lender for more. As opposed to 60%, now the borrower is only coming out with 40% out of pocket, right? So that one's less risky to the lender. They have less risk. Yeah, Plummer.
And by value in that ratio, you're talking about the appraised value of the property.
Or the purchase price, whichever is less.
Okay. Oh, okay.
So the value is the purchase price or the appraised value, which again, this is through the eyes of the lender.
Mm-hmm. Thank
Yep.
you.
Mm-hmm. Possibly in a VA loan, I mean, maybe even an FHA loan, you may see loan to value ratios at 95% or higher. Last I heard, FHA loans were requiring 3.5 down, which means the lender's being asked to come up with 96.5%. But remember, the lender feels more secure with FHA and VA loans because those loans are backed by the government. They're there to protect the lender in the event of the borrower's default. Basically, they're offering the lender a safety net, aren't they? So while it's 100% for a VA loan or 96.5% for a FHA loan, but they have that backing. I doubt we're seeing this for a conventional loan without a higher interest rate, more at risk for the buyer. I think most conventional loans are, I think the most one I've seen is 90%. Even that's pretty high for a conventional loan. Every single lender is different, you guys. Every single lender is different. They're like us. They all offer different product, a different service, which is another reason why we can encourage our buyers to shop around. They owe that to themselves. even if they say their cousin is, Bob from Bank of America, well, that's great. Call Bob, but what can it hurt you to talk to another lender, right? What can it hurt?
I think the misconception is that shopping around affects your credit score and
Absolutely.
yeah.
It was explained to me by a lender once that it's, even if they have 3 lenders hit their credit, it still shows up as one inquiry because it's one hit for the same thing, right? It's 3 hits for the purpose of originating a loan, but it's only going to show up as one hit on their credit. Does that make sense? So you're absolutely right, Plumber. You tell them to shop around and then they say, ooh, that's going to affect my credit. No, it's only going to be one hit because all 3 lenders are hitting for the same purpose. Now you flip that coin. I had a buyer once went nuts. She called me and said, so I've talked to 6 lenders. I said, oh my God. I said, are you confused with all the information you got? And she was like, yeah, what do I do? And I'm thinking you should have stopped 3 lenders ago, 2 or 3, just to give them something to do a nice side-by-side comparison. If they do 2 and the numbers are from here to here, then maybe they do a 3rd one. It's kind of like when you're getting quotes for stuff, right? You talk to 3. I usually don't want the highest. I don't want the cheapest. I usually like the person in the middle. That's me personally, but you have to have something to compare to know which one to choose, or they should. Other questions or comments? Okay. Let's take a break. We'll come back at 10:10. Talk a little bit more about buyers. All right. Welcome back. The other part of this qualifying a buyer is what we looked at yesterday. So I'm not going to go back through that. We did that today, but this is the summary of it. So remember, you have your two formulas, or you use your T-bar. Again, this is a math question you're going to see later this afternoon. So any questions on this? Did you guys get a chance to look at a couple practice problems yesterday? Good. Good. Again, there's only two math, you know, as with any exam you take with real estate commission, the math alone can't fail you, you know, but if you can get those two extra questions, then it might help get you, you know, work through something else. Before we move on for qualifying a buyer, just want to, again, we kind of mentioned this earlier, but just as a reminder, the different types of loans, all lenders have a different product. And remember, we said yesterday too, some sellers may not want to deal with the lender. Maybe they just want to deal with cash buyers, or maybe they just want to deal with conventional and cash. So we hash that out with the seller in the listing agreement. And then if they do have a limitation on the loan product that they're willing to consider, then we have a place in MLS to check what boxes are allowed. So just as a quick refresher, nothing you're going to see this afternoon, but a conventional loan, this is the one that's the most risky for the lender because they don't have a safety net. They don't have the backing of the government. So usually what the conventional loan does, if your loan to value ratio, I should say the lender's loan to value ratio is 80% or higher, that's usually when we see our private mortgage insurance, also known as our PMI. So the lender will charge the borrower insurance. They're creating their safety net by charging that PMI. And when you get your loan amount to under 80%, 79.9%, your PMI should drop off. So all lenders are different. If you pay it off, if you get under 80% early, you may want to contact the lender and say, hey, this is where I'm at, you know, but just keep in mind, some will do it automatically, some you'll have to contact. I called mine, like the payment, it dropped under 80%. I called mine and they were like, wow, yes, ma'am. I was like, hey, I'm not paying more than what I have to, you know, so the sooner I drop my PMI, and guys, we're talking, you know, minimal $6-12 a month, but still $6-12 a month, that's lunch, right? So yeah, I'm absolutely not going to sneeze at that. Conforming loans versus non-conforming conventional loans. Conforming loans are made to the underwriter's guidelines. So the underwriter that assists the lender, most lending companies have their own underwriting, have their own underwriting company somewhere. So if they're conforming, then they're made to the underwriter's guidelines. If they're non-conforming, then they don't conform. So whether or not a conventional loan is conforming or non-conforming, conforming conventional loans tend to be more sellable on the secondary market because the secondary market knows that those loans have conformed. They met various guidelines. Non-conforming, then, not saying they're not sellable, but they just might be harder to sell. And then our government loans, again, as we mentioned, your FHA loan, your VA loan for our qualified veterans, and then USDA, more rural loans. You're not going to get a USDA loan in downtown Winston-Salem. So USDA, and if you're ever working with a buyer that's interested in going USDA, USDA has a website. You can go to Google USDA, and when you go to USDA's website, you can find a map, plug in your address, and it'll tell you right then if it's in a USDA allowable. So if you have a buyer going USDA and the property's not in a USDA zone, then don't show them that property, because you know you can't get USDA financing for them. Just real quick too, I just want to make sure we're good on the difference in pre-approval and pre-qualification. Pre-approval, the buyer has talked to a lender. The buyer has shared their information. This is my debt, this is my income, this is how much I make, this is how much I owe. And based on the information submitted by the buyer, the lender will issue a pre-approval. So the lender's not verified, they've not asked for proof. They're solely relying on what the buyer tells them. Pre-qualification is taking that a step further. The buyer submitting their debt to income and the lender's verifying. So through the eyes of the seller, pre-qualification letter might be a little bit stronger, right? It might be a more, because now the seller knows that not only if I spat out some numbers of the lender, but the lender is verified, this is my income, this is my debt. Some lenders don't issue a pre-qualification until you get under contract though. So another reason to maybe shop around and be familiar with your local lenders. Yeah, Plummer.
I was going to say, it's my understanding of that was the other way around. It's interesting
What's that?
that
Approval?
pre-approval was basically taking it a step further, and they've got information from you, and then pre-qualify was so
Yep. So pre-approval is just the lender verified numbers. I was in a I had buyers in a multiple offer situation. I knew we'd have a stronger offer if I could get a pre-qualification letter. And the lender looked straight at me and said, I mean, we were on the phone, but I could feel her gaze boring down at me. And she said, you got that backwards. I need a contract before I can issue a pre-qualification. And I thought, well, how does that help my buyer get the dang contract, right? How does that help them? So honestly, I haven't recommended that lender since then. I would rather work with the lender that, helps my buyer get the contract to begin with, and if that's something, especially as competitive as this is right now, if we can get the buyers, the further along we can get the buyers in the process, the better they look to a seller. So there's a whole lot of things to take into consideration. Some sellers may not want to work with the lender's name that they don't know. Maybe they don't want to work with the local lender. Maybe they want a brand name. Some sellers look at brand names and say, I'm staying away from this. Just the name of the lender may have some sort of decision on the sellers, which one they're going to accept. I mean, guys, when they got 40 some offers, they got to have something, some way to select it, right? I mean, they got to have some way to pick one. So it might come down to the lender, and the lender, just the reputation, just bottom line reputation. Again, selecting properties. We want to show properties based on the buyer's needs, wants, and of course, what they can afford. Especially in this market, you guys, buyers almost need to be prepared to pay more than asking price. So let's just say they're approved for $350,000. Let's just say that's their approval amount, what they're allowed for. I would be reluctant to show them a home listed at $345. Because I know they only have $5,000 more in wiggle room, right? So maybe if they're pre-approved for $350, maybe we don't try to max them out unless they have the money, unless they can provide me with a proof of funds to show that this isn't an issue. But if they're pre-approved for $350, you might want to consider them showing them properties in the $320s or the $310s or the $330s. You guys with me? So when they need to make an offer for more than asking price, they're still staying under their approved amount. I think it's important that we're aware too that interest rates are creeping up. We saw 5% last week, didn't we? Which, by the way, 5% is not a bad interest rate. Please don't get, when my parents bought their house 25 years ago, I think like a 13% interest rate or something crazy like that. So 5% is not a bad interest rate. It's not as good as 2%. I will give the buyers that. It's not as good as 2%. But as we start seeing these interest rates creep up, if you had a buyer that took time off, if they got pre-approved when interest rates were 4 point something and they took time off and now they want to look again that interest rates are 5 point something, you need to have them talk to a lender again, because that affects their allowable monthly payment. That affects how much they're approved for. So if it's been a while, you may want to have them go back to the lender, make sure they can still afford to look in this price point. Does that make sense? As these things change, we got to stay current. So financial qualifications, and again, their needs and wants. I always have buyers. I encourage them. Again, I can't make anybody do anything, but I always encourage, let's go old school. Let's take a legal pad, right? Needs on one side and wants on the other, and draw a line down the middle of it and have the buyers list out needs versus wants. What's something you absolutely cannot live without versus something you'd really, really like to have? And how flexible is that needs and wants list? Again, keeping in mind that buyers' minds change. So just be prepared to reshift and regroup. Obtaining cooperation. Again, this is referring to making sure that we as the buyer's agent get paid. So when you look in MLS, when your buyer says, I'm interested in 123 Main Street, you log into MLS, you're probably going to look at the listing agent first, see who it is. And then after that, you're going to look at commission. How much are they offering you? And if it's not what your firm expects to receive, then you collect some from the listing firm and you collect the rest from the buyer. That's why we have our buyer's agency agreement.
Julie, just to go back for a second on the wiggle room. So say for instance, someone, they, like you said, the number was 350 that they were pre-qualified for, right? So say they, got something that was 320. And so that left, plenty wiggle room, but the house didn't appraise for anything over the 320. Is that still wiggle room, or is it based on that appraisal?
It's going to be on whichever's less, the appraised value, the purchase price, whichever is less.
Okay.
Okay. So if we go over that, whatever that 320 or, in your example, again, that's pretty much got to come out of the buyer's pockets, right?
Okay. Even though they were approved for up to that 350.
That's right. Because the lender is going to issue the loan, that loan to value ratio, the purchase price or the appraised. The lender doesn't care what the buyer's willing to pay for it. The
Right.
lender cares about the value, and the
Gotcha.
value is defined as the purchase price or appraisal, whichever is less.
Gotcha. Thank you.
Yep. Yep. Again, the lender, that's the lender protecting their interest. If the buyer defaults, the lender wants to know that they can sell the property and get their money back. And I think we tend to think of buyer defaulting, 10 years into home ownership. Guys, I've heard a couple stories in my day about buyers never making their very first mortgage payment. So the lender has to consider that worst case scenario. Basically, they got to turn around and sell the house for about what the buyer paid for it, right? If not more, so the lender can get their money back. And that's what the lender, as time goes on, the lender's liability diminishes, right? As they pay down the house and build equity, that's less liability for the lender. But yeah, I've heard twice now in my years, I've heard of buyers never, ever making their first mortgage payment. I don't know what happened, but for the lender, that's the worst case scenario right there. So we're retaining cooperation, make sure we're getting paid. If the seller or the listing firm's not paying us or paying us enough, then we have the discussion with our buyer. And then we're going to schedule showing appointments and show selected properties. Maybe it's kind of late, isn't it? Again, here in the triad, we use showing time. It's a centralized showing system. Those of you who use showing time, pretty cool. Hey, you can go into one place and schedule appointments with different listings by different firms. If I may age myself, I'm older than showing time. When I started in the industry, showing time was mind-blowing when we got it. When I started in the industry, you had to call every firm. So if you were doing 13 showings and 13 homes listed by 13 firms, you were making 13 different phone calls. So you called. That's what I started doing. I was a receptionist. We had a program called Call Tracks. I think it was a Lennox program. It didn't recognize my mouse. Woo, how old am I sounding over here? But yeah, you had to call me and schedule your appointment, show me your date and time. And then I had to contact the seller and get approval and then call you back. So again, if you were showing 13 homes in one day, it was a day just to set these up, wasn't it? Now, thank you, showing time. We go in, we say, I want to see this, this, and this, click and click, and these times, and da 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 da. And by the way, you guys, back in the day, I only worked Monday through Friday, 9 to 5. So I'm not sure what people were doing that wanted to show property evenings and weekends. I wasn't there to schedule it for you. So you had to plan ahead. Yeah, now you got, that's right. You call showing time now and you can tell they're working at home because you hear their kids in the background. You hear Young and the Restless on, you know, you got, so you know, showing time is working at home these days. If you're scheduling a full day of showing, you want to take into account, I mean, one feature I like about MLS is I can get directions. So it tells me how far away from point A to point B, house A to house B. So I can incorporate driving time into my showing times. You want to incorporate breaks. If you're showing 13 homes all day, you may want to stop at some point and take lunch. You need to incorporate potty breaks, pit stops. So just kind of keep all that in mind as you're scheduling. I had buyers come up once. He came up from Florida. He was going to spend a week with me. He had me for the whole week, and I was going to show him properties. His criteria was 45 minutes away from PTI. So PTI is we were in Asheboro. We were up in Danville, not Danville. We were still in North Carolina, but we were close to Danville up there. I mean, I got the grand tour of the Triad. All the times I talked to him, he neglected to tell me that he was going to bring his wife that was 5 months pregnant with twins, his 3-year-old son, and his father, who was probably late 60s, early 70s. Bottom line, I didn't plan enough potty breaks because I didn't know this pregnant woman and kid and gentleman were going to be with her. I regrouped after day 1, but that information would have been helpful, I think, in all the times that I talked to him that he was bringing the family. But sometimes now I ask questions, who's coming with you? You know, so sometimes we learn the hard way. But just, you know, if you're out all day, just make sure you plan appropriately. Some buyers can walk in the front door and say, nope, this isn't it. Some buyers want to hang out for hours and hours. So just try to do the best you can to honor your showing times. You know, tell your buyer, look, we can do a second showing. You know, we got to get to the next appointment. We got to keep moving. We're probably not doing that this much in this market because we got to see them as they hit the market. But I promise you, it'll come back to a day. I actually miss a day of showings, 10, 13 in one day. That was always a good. I drove separate so I could have a minute to me and my radio in between showings, regroup. I can scream it out to some 80s music and it just kind of levels me again and brings me back center. So that's what I need. Buyers were helping discover and disclose material facts. Is everybody good with this? Do I ever have a reason not to disclose a material fact? I wish I saw more head shaking. No, I never have a reason not to disclose a material fact. I don't care who you are. Are you my client? Are you my customer? I owe you the disclosure of material facts. I don't care who I am. Am I the listing agent, the buyer's agent, seller sub-agent, dual agent, designated dual agent? It doesn't matter. I always have a duty to disclose material facts. So we're going to assist our buyer, disclose material facts. Help your buyer with inspections. Again, give them choices for home inspector, pest inspector. And probably one of the important things that we need to do is help our buyer with the walkthrough. Make sure our buyer understands the importance of the walkthrough. I try to do mine on my way to the attorney's office, if at all possible. Because when your buyer signs at the attorney's office, they're signing, acknowledging that they take this property in its current condition. So if they haven't seen the property in its current condition, do they really know what they're signing? So if we go to the walkthrough and they see something they don't like, they basically have two choices. They either go to the attorney's office and sign or they don't. So if we find something in the walkthrough is, I think, especially important if we've never seen the home vacant. But even if we've seen the home vacant, still do a final walkthrough. And if your buyer refuses to go, it's recommended that you do the walkthrough anyway and video it, document it as you go. At least you can have your eyes on it. And if a question comes up, you can say, well, first off, I gave you that option. You said no. But second off, when I took my video 20 minutes before closing, that big hole wasn't in the wall. So I'm not sure what happened after you moved in, but it wasn't here before. You guys with me? That could be one way to protect yourselves. I've only had one buyer. She didn't refuse to go. She just couldn't go. They were actually out of state. So we had to do a mail away. And I did a video walkthrough, but you guys have problems with that? Anybody not wanting to do the walkthrough? Good.
I got a question. So what happens if in the walkthrough something is not what it was when we entered into the contract? And
Buyer
I
has
mean,
two choices.
like a serious something.
The buyer has two choices. They either go to the attorney's office and sign accepting the property in its current condition, or you call the listing agent and say, we're not going to show up until you fix this. Buyer's
We're
got
not going to show
choices.
up to the closing, you
If the
mean?
buyer signs, they're accepting the property as it is. So if they're not good with the property as it is, their only recourse is not to sign.
And if they don't, are they in breach then?
Well, we got a couple days to work this out, right? We can call the seller and we get the seller to fix it. Maybe the two can reduce the purchase price, right? I mean, it's not over yet, but don't tell your buyers we'll sign and then we'll get the seller to take care of it. Because once they sign, it's a done
It's
deal.
theirs.
It's theirs. And they're signing acknowledging that. So that's a tough choice, isn't it? To look at your buyer and say, you got two choices, you either sign or don't sign. There's a reason. There's not much more that makes me more nervous in this world than when the buyer starts talking about coming to closing in the U-Haul. Because what if we don't close? Where you gonna go? You gonna sleep in your U-Haul that night? So I always, and for reasons like that, for example, I always have my parties have a plan B. Because you're right. What if we've never seen the home vacant and then the seller moves out and behind every single one of these pictures is a big hole? All these pictures are here covering the hole. And now we're seeing it vacant for the first time. And all we see is that the buyer has two choices. They either accept the property with all these holes, or we call the listing agent and say, you'll need to get over here with some spackle and fix this before we sign.
Hey, Julie, on my
Yeah.
son's property, we kind of knew the people that they were buying from. So we kind of trusted them. And so we did not do a walkthrough. Yeah. And when we got there, after they closed, the doorbell camera was gone. So they had taken the doorbell camera off the house.
Off the house. So they removed a fixture.
Yep.
So you guys had to buy a new, I mean, there's no recourse there, right? Because the buyer acknowledged that. They may not have known what they were acknowledging, but they acknowledged that.
Yep.
That's again, it's kind of the hard reality for a buyer. You know, there's not, I mean, I'm not saying there's never a case where they can sue the seller afterwards, but it's going to be tough. Partly because the judge is going to say, but you signed here saying you were taking this property. Chassie, did you have?
I was just going to give an example because I had that example, like the thermostat. The
That's
house
right.
closed in November. And when we went to the final
Gosh.
walkthrough a couple days before closing, they had like a smart system, like a smart thermostat that ran like cameras inside and outside of the house, had alarms on the doors, and it ran a smart thermostat that went with it, ran the HVAC. And when we went to the final walkthrough, there was a hole where the thermostat was. All of the cameras and sensors had been removed, and so the HVAC didn't work anymore. And so I took pictures of everything. And as soon as we left the final walkthrough, I called the listing agent and said, you know, we will have to delay closing if we cannot get this fixed. And so, you know, he had a couple of days. But and ultimately what happened was the seller wouldn't return it. And so in order to go to closing, the listing agent had to cut my buyers a check.
Wow.
for the stuff that was missing,
For the
because they
stuff.
couldn't turn on their heat or their air because they didn't have a
Right.
thermostat.
So you have an inoperable system if you don't
Right.
have a controller, right? Right.
Right.
Could you imagine how upset your buyers would have been if you hadn't done the walkthrough, if they hadn't have found that? You know what I'm saying? So final walkthrough is oh so very important. And the buyers have a decision to make. They have a choice, and it isn't it. I never said it was an easy choice. It's never an easy decision, but those are their choices. You either sign or you don't. So good for you. I hate it for the listing agent, but I bet you going forward, the listing agent will talk to all sellers. Thermostats remain, ring doorbells, don't leave me holes in the walls. I bet you that's a hard lesson learned. And that's part of that agent's to-do list now when they're talking to sellers. I hope, anyway. Other comments about the walkthrough? We need to do a CMA for our buyer. Why are we doing it for buyer? Well, when your buyer looks at you and says, this is the one, let's write it up. How much should I offer? Don't just blurt a number out. Don't just say, well, everybody's going over 20,000 over asking price. Don't blurt a number out without doing some research. And the research you're going to do is a CMA. Remember, what we're finding is probable sales price. So when you find probable sales price for that buyer, they say, okay, well, I see probable sales price is 150,000. Can I offer 175 to make this a better offer? Of course you can, but that's on them, right? I can't make them. I can tell them their options, but I can't make them. I think I mentioned this the other day when we were talking about CMAs with the sellers. My firm has recently started having buyers and sellers initial these things, just in case it goes down that we didn't discuss it with them. Now we got their initial on the CMA itself. I don't know if that'll hold up or not, but we're taking that extra step because now buyers are starting to get upset that they overpaid and they're claiming that they didn't know. So one way that we can protect ourselves is to have them initial and put it in our transaction file. Anybody else's firm doing that yet? Blow your bick away. Offer that suggestion, see what they think about it, but just something to consider. Buyers buy, and they're not happy, and they want to sue somebody, or they want somebody to suffer, and we're a good first line of defense. So keep you out of real estate jail, keep you from having to pay for a new thermostat in some cases. So CMAs for buyers. Again, same thing we talked about with sellers, land use restrictions, zoning, covenants, anything like that that may restrict how they use the land. Again, you guys, if it's important to my buyer, then it's important to me. So if they share with me, you know, I'm buying this house so I can fill in the blank, start a daycare for my home. I now need to make sure that zoning allows residential and commercial, right? That they can operate a business out of their home. If it's in an HOA, I need to make sure that the restrictive covenants will allow it as well. So help your buyers find those land use restrictions, especially if they have a particular need, a specific importance. If they're buying in an HOA, whether or not they express a concern or not, help them get their hands on the protective covenants. If they're buying in an HOA, you know, the commission says we should try to get these to them before they present the offer. And I think in a normal market, that's doable. But in this market, we may not have time to get them. The house may be gone by the time. So help them get them as soon as we possibly can. It might be while we're under contract, hopefully not, but help them get those covenants. Covenants are pertinent. Anybody remember that fancy word? What's a pertinent mean?
Everything.
Goes with the
Everything, guess
property.
what? Goes with the property.
Property,
It
yeah.
runs with the land.
Yeah.
So if it's a pertinent, it's going to attach to this homeowner and the next one and the one after that and the one after that and the one after that. So covenants just don't stick around for the first buyer. They stick around for all subsequent buyers, all subsequent owners. My job is to help the buyer and seller obtain the covenants. help them get the information. Are you guys, is anybody an attorney? I'm sure I've asked this before. Donna, no, you're not. Okay, so we are not attorneys, which means I cannot interpret legal documents. Okay, we are not attorneys. My job is to help them gather the facts. I'm a data collector. So I help them get their hands on the covenants. I cannot and should not interpret those covenants for them. If they have questions about them, either get them to their attorney or the HOA. They can help address any questions as well. Everybody good with that? Y'all start practice telling yourself, I'm not attorney, because they're going to ask, Julie, what does this mean? So we need to be prepared. As we mentioned, zoning, local ordinances, how you can use the land structures if they want to build, if they want to, setback restrictions. Let's say, for example, the home has a detached garage, and over the detached garage is a finished apartment space. And the property is zoned single family. If it's zoned single family, how many families can live on that property? Just one. So you hear your buyer talking about, ooh, that's a nice apartment over the garage. When we get it, we're going to rent it to a college student. Now, how many families live on that property? 2, and you got a violation of zoning. These are the kind of things that we need. This is why we ask questions. Hey, that's a nice garage. What you going to do with it, right? I'm not being nosy, you guys. I'm making sure that my buyer's end use is allowed. So ask questions. Are you going to let your son live there? Or are you going to rent it to somebody else? You with me? Only one family is allowed. So ask the questions, know the zoning. Each zoning has, or each city or county, municipality has its own zoning website. Just go to Google, Winston-Salem, Forsyth County zoning. It'd be a great place to start. For the most part, well, in the Triad MLS at least, zoning is a required field. So the listing agent has to enter zoning before they can enter the listing. For the most part, as a buyer's agent, we should be able to rely on the zoning listed in MLS. But if your buyer has a specific need, or if a flag goes up, then we need to investigate it on our own. So if there's any questions, any flags, or if your buyer says, can I use my property to do this? Then we need to help them be sure that their end use is allowed. If the property's in a flood hazard, a flood zone, they may have to pay flood insurance. Flood insurance is not cheap. So again, that buyer that's about maxed out on their allowable loan amount, you tack on flood insurance, and that may push them over the top. That may push them, and if that's the case, we're not going to get loan approval. I always try to look at a flood map before I write an offer up for a buyer. Just a quick look, understanding I'm not FEMA, I'm not a lender, I'm not a surveyor, but at least I can get an idea. If the buyer is getting a loan, then they will be required to get homeowners insurance. If it's a cash buyer, homeowners insurance is highly recommended. So it's only required if a lender's involved. Again, get them shopping around with homeowners insurance early on in due diligence, because if we find out, not all properties or people are easily insurable. So we go under contract and we find out that the property or the person has a big claims history, their premiums might be higher. And if their premiums are higher and we have to tack on flood insurance, if we have to terminate, the best I can do for my buyers is get them to terminate while we're in due diligence so I can get their earnest money back. So have them shop around for homeowners, to call Jake from State Farm and Flo from Progressive and give them a name of a couple different people to talk to so they can shop around. Again, not all homeowners insurance are created equal either. So make sure they can afford it. Again, if they're getting a loan, the lender's going to require it. Period. End of story. finishing up talking about some other additional responsibilities of a buyer. We're going to help them prepare their offer. We're going to fill in the blanks for them, but we're filling in the blanks with information provided by them. We have conversations. How much do you want to offer due diligence, earnest money? When do you want to close? Do you want any seller pay closing costs? We're going to help them by handling contract matters, negotiating, letting them understand when they go under contract, assisting them with their due diligence, their inspections, their investigations, their surveys, gathering all the information they can, and then getting them ready for closing. This and more, if you haven't taken 302 yet, contracts and closings, you're going to spend quite a bit of time with the buyer's due diligence, with the closing, going through that process. So you're not done working with buyers yet, unless you've already taken 302. So if you've taken 302, you've seen all this. If you haven't, you know that this is to come. So you have that little bit more buyers to work with. Any questions on buyers? Does anybody have a preference yet for those of you that are practicing? I know everybody wants sellers in this market, but that'll switch. Anybody have a preference yet? Buyers or sellers? You going after one more the other? Are you still hungry and you'll just take any business you can? That's kind of always the way I felt about it. I like to
Pretty
eat dinner.
much.
Yep, I like to eat dinner. So wherever I can get it, I'm not particular. Again, in this market, everybody wants sellers. Guys, 20 years ago, when I started in real estate, they said the successful agents are the ones that can get listings. And I've seen that proven true over and over again, especially true in this market. Bottom line, we are salespeople, and salespeople have to have a product to sell. So if we don't have inventory, if we don't have product, what are we doing? So I've always heard that the successful agents are the ones that can get the listings. So even when we normalize and that pendulum swings back, one day we'll be back in a buyer's market. The sellers will have zero control. The buyers will be laughing. All those sellers that did them dirty today, the buyers will get theirs and they'll be laughing, but we still got to have listings to sell. So now let's talk about, we've talked about working with sellers and we've talked about working with buyers. So now let's talk about working with both buyers and sellers as dual agents and designated dual agents. The simplest definition of dual agency that I can offer you, I cannot figure out how to make this any smaller. I'm open for suggestions. The simplest definition I can offer you, dual agency. One company, one transaction, two clients. The seller has hired the firm to sell 123 Main Street. The buyer has hired the same firm to help them purchase 123 Main Street. Both buyer and seller are represented by the same firm in the same transaction. Maybe dual agency is one agent working with both buyer and seller. Maybe it's two. When we talk about the company, understand, anybody's company have multiple office locations? Chastity's does, I think. Yeah. How many office locations do you have? Do you know offhand?
It's several.
Several. Okay. So you got like Winston, Kernersville, let's just say. Even though they're in different office locations, they're still the same company. You guys with me? So if your company has multiple locations, you're still with the same company. So dual agency doesn't just happen under the roof. Dual agency happens under the company umbrella, multiple office locations. In dual agency, let's talk about where we've been so far. So we got a wall. And you got this, actually, let's put the buyer over here. It doesn't matter, but let's put the buyer on this side of the wall. Let's put the seller on this side of the wall. And where we've been talking about so far, you have one company on one side of the wall with the buyer, and you have a different company on the other side of the wall with the seller. This is when you're exclusively working with the buyer as a buyer's agent, or you're exclusively working with the seller as a seller's agent. This is what we've been discussing so far. So what happens in dual agency, the buyer's still on one side of the wall, the seller's still on the other side of the wall, right? That part hasn't changed. What happens in dual agency is the firm and all the agents in the firm now straddle the wall. Nobody's standing over here with the buyer and seller. They're hanging out on their own, aren't they? The firm and all the agents in the firm are now straddling the wall. We now have a duty to offer everybody equal loyalty, equal old car, equal everything. The thing about dual agency, my role changes. The buyer's still buying, the seller's still selling. When we enter into dual agency, the firm nor any of the agents in the firm can offer advocacy. We have got to take a few steps back and represent both parties fairly and equally. Remember who my relationship is with. The buyer's relationship is with who? The firm. The seller's relationship is with who?
The
The
firm.
firm. So when both hire the same firm, we have to figure out how we're going to serve both the same, and we do so by straddling the wall. Everybody gets the same fair and equal treatment. There's no advice I can offer one party that won't harm the other. Let's say, for example, your buyer wants to make an offer on a listing your firm has, and your buyer says, how much should I offer? Is there a way that you can answer that without harming anybody? Can you tell them to offer asking price? What if it's not worth asking price? Can you tell them to go in under asking price? Well, no, because you just hurt my seller. Can you tell them to go over asking price? No, because now you just hurt my buyer. There's absolutely no way you can answer that question without harming somebody. And that's what we have to avoid. And that's why we step back. We no longer can offer that advocacy. Yet another reason why buyer consultation appointments are so important. By discussing possibilities with sellers, let's try to have some of these conversations up front before we find ourselves in a dual agency situation, and I can't. We talked about Cam earlier. Let's go back to football for a second. I like the sports analogy when talking about dual agency. When you're watching a football game, can you tell there are two different teams on the field? I don't care if you're a football fan or not. Can you look at the field and see two teams running around? One's wearing whites and one's wearing grays, right? You can clearly tell that there are two teams. One of those teams is the buyer. One of those teams is the seller. Don't both teams have a coach standing off on the sidelines? Make this play, throw that throw, stop that guy, right? Don't they have somebody off to the sidelines? I am the coach when I can offer exclusivity. I am the coach when my buyer is not represented by the same firm as my seller. When we go into dual agency, though, I can no longer be the coach, because now I got to make sure buyer and seller both play fairly. So when we go into dual agency, my role changes. I'm no longer the coach. I become the referee. Am I still involved in the game? Yeah. Am I still an important part of the game? Yeah. Should I be telling Cam what play to make next? Should I be telling Cam to throw it in the end zone? Hopefully you're not going to make it as a referee if you're doing that, right? And that's what we mean by advice. I'm still there. I'm still making sure everybody gets from point A to point B, but I can't offer advice. And that's what dual agency is. It's the firm that has the loyalty and the duty to have both sides fairly and equally. In order to have dual agency, we have to have informed written consent. Dual agency does not just happen. We have to discuss dual agency with both parties. We're getting ready to look at this in our listing agreement or our buyer's agency agreement. We don't do both. But the listing agreement has dual agency explained to the seller. The buyer's agency agreement has dual agency explained to the buyer. They pretty much say the same thing, just one says buyer and one says seller. If we just start acting like dual agents without having that informed written consent, we've engaged in undisclosed dual agency. Undisclosed dual agency is a violation of license law and commission rule. So when we say we enter into dual agency with informed written consent, that means we have a conversation with both people. That does not mean we hand them a piece of paper and say, we're going to do dual, sign here. We discuss it with them. We have a conversation. They have a right to know what they're giving up if they agree to dual. And it's our job to explain that to them. Dual agency can be oral at first if you have an oral buyer agency agreement with a buyer. So our exception there, again, I'm not just going to act like a dual agent. I'm orally going to explain it's an express agreement. So I'm still going to state the terms, even if it's a conversation. Oh, so now you want to see one of my firm's listings? If we proceed, this is what it's going to mean to you. And then you go home and you follow it up with an email. Because what do you document? Everything. So when you have the conversation, you still go home and follow it up so you have proof that you did it. So for authorizing, again, I have to have an advance consent of both seller and buyer, both parties. If both parties agree to dual in writing, we may want, okay, let's just say, actually, let's take a break. I'm sorry, let's take a break and then we'll talk about this before we get into this. Woo, watch your time, Julie. All right. So it is 10:57. Let's come back at 11:07 and we'll talk about dual and we'll get into designated. All right. Welcome back. So we're talking about dual agency. First off, let's all be good. If either party says no to dual, can we proceed? No. If either party says no, they've pretty much already said they don't want this transaction to happen, right? So let's back up. You're at the listing appointment, you're meeting with the seller, you go over dual agency, and they say, nope, not going to do it. Can we all agree dual agency is not what's in the best interest for the buyer and the seller? Not even a little bit. You know, we're all in real estate, we say, because we want to make lots of money and we want to help people. And now here I am babbling on about situations that you may not be able to be people's best advocate. And that kind of goes against everything you thought when you signed up on day one, right? And I totally get that. So your seller says, no, this is in no way benefit for me. I'm not going to do dual. And you say, okay. You say, seller, this is what you need to understand. If you say no to dual, what you're saying is no agent in the firm can bring their buyer client. If you're in a firm that has 400 agents, they're limiting that pool of buyers. Everybody with me? No agent in the firm can bring their buyer client. Could we bring our buyer customers? Yes, because dual is how many clients? 2 clients. So if one's a customer, dual's not a situation. Everybody with me? So the seller says, well, gee, you got 400 people in your firm. Are you telling me that none of those agents, that's exactly what I'm telling you. Nobody can bring their buyer client. Maybe explaining the repercussions of saying no to dual can assist the seller. Maybe they change their mind, maybe they don't. Now flip that coin. You're working with a buyer. Doesn't matter if it's an oral buyer agency agreement or a written buyer agency agreement. We still discuss it up front, but with buyers, the true conversation comes when the buyer wants to see a listing that your firm has. So maybe you met the buyer 2 months ago, and for the last 2 months, you've been showing them other people's property. Fast forward to other people's listings. Fast forward 2 months, and now they're interested in one that your firm has listed. Do they remember the conversation you had with them 2 months ago? Probably not. So at this time, when they go, oh my gosh, 123 Main Street's adorable, can we look at it? But first, we need to have a rediscussion about dual. So we readdress it. We remind the buyers what they're agreeing to. If the buyer says, nope, I'm not going to do it, can I show them 123 Main Street? No, because the buyer's already said no. So sometimes what I want you guys to understand is that sometimes people change their minds, and they're allowed to change their mind, and we can help them change their mind. Sometimes today looks different than tomorrow or 2 months from now, however far down the road. So let's walk through some scenarios. If you have authorization to dual agency, if you have advanced consent by both buyer and seller, both parties have said yes. They've already agreed to dual. Buyer sellers we have in writing, buyers maybe we have an oral, maybe we have in writing. We may want to remind them, again, it depends on how long it's been since we've had this conversation. So we may want to remind them, remember you said yes to this, and now we're here. So let's refresh what that means. What if we have advanced consent by one party and the other party has said no? Again, it doesn't hurt. Now that we're here, now that you have a buyer interested in your listing, now that we're actually here, it doesn't hurt to revisit this. Maybe that one party can change their mind. Maybe when we go back to that party, so remember, you said no. And by you saying no means I cannot show you this listing. If you change your mind, I can show you the listing. If the seller's always in writing, If the buyer's in oral, we can change our minds orally to allow the showing. So we can get oral consent from either party to change their mind to allow the showing. If the buyer proceeds and presents an offer, then we need to get that change in writing, which means we need to go back to the agency agreement, strike through the no, have everybody initial yes, and then date it. Everybody with me? So if it's oral, I can get a change in oral to allow the showing. I still have to put it in writing before I present the offer. So if they walk in the door and say, oh God, no, we have nothing to change, do we? I just had to get permission to walk in the door. Same thing if either party says no. If either party says no, I just don't want you guys to think that you can't revisit it. If they say no at the beginning, I get it. Once again, this market that we're in right now is not always going to be the market that we're in. And you're going to have a time where sellers may sit on the market for 4 months, 6 months, 8 months. If the seller's been on the market for 6 months and never had an interested buyer, they've said no to dual, never had an interested buyer, and then all of a sudden a buyer from your firm shows up interested, is the seller probably going to change their mind? They're probably singing a different song now than what they were 6 months ago, aren't they? So this is why it's not an end all be all decision. We can revisit it as it comes up. So we have the conversation up front about what could happen, but when it's actually happening, we need to go back and revisit. And if anybody said no, give them the opportunity to change. I had buyers once. A common misconception with dual agency is that I'm personally representing both. I think the common misconception about the public is that I represent the client, not the firm. And I had buyers once and we talked about dual and they said, I just want you working for me. And I said, hey, I hear you. I hear you. And I said, what if somebody else in my firm has it listed? And they said, well, what's that mean to us? And I said, it's the firm that represents you. I'm an arm of the firm, right? I'm an extension of the firm. At that time, they were looking in Summersfield, Oak Ridge, that area. And at the time, my firm didn't have a listing there. So as long as they stayed in that geographical area and nobody from my firm listed anything there, then it wasn't going to be an issue anyway, right? So everything we were looking at anyway was not one of the firms. And I discussed this with him. I said, if we get a listing that's attractive to you, we're going to have to revisit this. But what they were telling me is they didn't want me being on both sides. What they didn't understand is that I'm an extension of the firm. By default, I would have been on both sides. And this is where we can help educate the public. So again, we just kind of left it at no for now. If we need to come back and revisit it, as it turns out, we didn't have to. Sellers, we got to get their agreement before we ever list a property. It's part of our listing agreement. Buyers, we may not have to have that serious conversation. Remember, buyers are timid, scared little creatures. So if you meet them on the first day and start busting out dual agency, you might scare them off. So maybe wait until that opportunity comes up before you have that hard conversation with buyers. Don't scare them off if you don't need to. Comments on that? Questions? Experiences with dual agency yet? Yep, Chastity. What role were you?
I was the listing agent, and several agents from my office put in offers, and one of the offers that the offer that my seller accepted was from an agent that's in my same office. And so we were in dual agency at that point. And so what Berkshire Hathaway does is we have a dual agency form, so that if it is a dual agency situation, there is a form that, like, if I'm representing the buyer and it's someone in my firm listing it, when I submit the offer, this dual agency form gets sent with the offer to say that they recognize that it's dual agency and they have given consent.
Nice. So you get it twice in the listing and the agency agreements and Nice.
It's like to say that we have verified it and had the discussion with them now that the situation has arose and that,
Now that we're
every-
here.
right? And then the seller
Perfect.
also has to sign it if they accept the
Nice.
offer to say that they
Nice.
acknowledge it as well.
Yes. Very good. I like that. Anybody else yet? You will. Don't worry. When you have a listing, you put a for sale sign in the front yard. It's got your name and phone number on it. Why do you put your phone number on the sale sign in the front yard? Because you want buyers to call you, right? Dual agency is a phone call away. We tend to think that it could happen with large firms of 400. All you need is a one-man office with one listing, and you're in the potential for dual agency. So don't let that deceive you. Oh, I'm only joining a firm with 5 agents. All you need is one listing. Dual agency is a phone call away. Everybody with me on there? So again, the sellers we discuss up front, we got to have it in writing before I can proceed. The buyers, maybe we just dance around it, but as Chastity said, actually hit it, actually discuss it when that opportunity comes up. Again, what we've been saying, the problem with dual agency is it limits certain information. Even though I'm in dual, that still doesn't give me the golden ticket to run around blabbing confidential information. Okay, let me just go ahead and get that out in the beginning. So if I know about seller's price, term, and motives, just because I'm in dual doesn't give me the right to call the seller and say, I know how much they're willing to offer, to call the buyer and say, I'll tell you why they're actually selling, right? So just because I'm in dual doesn't give me a golden ticket to run around blabbing. I still owe everybody certain levels of confidentiality. I have a duty to disclose material facts, even if I'm in dual. But I'm limiting certain information. I'm limiting certain disclosure, certain information to the property, to the principals. Again, when the buyer says, how much should I offer? I can still do a CMA for them, and I'm going to do a fair CMA. I'm not going to do a CMA that favors the buyer's offer over the seller's, right? And if the seller says, I want to see a fresh CMA, then I'm just going to do one and send it to both, right? I'm going to provide both of them with the same information. So I can still help. I just can't offer advice. And really what we're limiting our duties of is loyalty, skill, care, and diligence. Again, the big thing that goes away with dual agency is advocacy. Y'all write that word down, advocacy. That's the big thing that goes away with dual agency. I can't be an advocate for one party. I got to treat both equally and fairly. Some firms offer a possible solution to dual agency. Some firms offer designated dual agency. Designated is optional. Whether or not your firm offers designated is up to your firm's policy. The firm's policy has to spell out designated and how it's going to work. And basically in designated, the BIC, presumably, or whomever's allowed to per the firm's policy, designates one agent to work exclusively with the buyer, and they designate a different agent in the firm to work exclusively with the seller. Designated is a form of dual. So one address, one firm, 2 clients. But in designated, there's always 2 agents. Designated is never one. So essentially what happens in designated, the broker in charge kicks one agent off the wall to work exclusively with the buyer. And then the broker in charge kicks a different agent off the wall to work exclusively with the seller. Where is the firm?
Still on the fence?
The firm's still straddling the wall, aren't they? The firm and all the other agents are still in dual. Their role, their relationship is still that of a dual agent. It's just that 2 agents have been designated, one to work exclusively with the buyer, one to work exclusively with the seller. And now that they're designated, those 2 are separated by a wall, aren't they? And now that they're designated, those two agents can proceed. They might as well be with two different firms. Now their advocacy comes back. Now those two change roles again. They went from a coach to a referee, and now they're going to change again and go from a referee back to a coach. They're back on the sidelines telling Cam what play to make next. The firm is still acting as the referee. The firm is still straddling the wall. We can't be designated if we have received prior confidential information about the other side. So if the agent that's been working with the buyer knows anything that could harm the seller in their negotiations, anything at all, if they know anything about the seller, they can't be designated. And same thing with the agent that's been working with the buyer. The BIC is responsible for making sure prior to designation, Chastity, do you know anything about my seller that can harm them? Donna, do you know anything about my buyer that can harm them? They should be making sure, they should be verifying. So what if one of the agents knows something about my seller? Let's say the agent that's been working with the buyer, maybe their kids play soccer together and they're in the PTA together, and they may know why the seller's selling. This agent can't be designated. So the firm, if the parties want designated, the BIC needs to find another agent to work with their buyer. Maybe we'll get agent number one a referral fee. Maybe we'll still get you something to get you paid. But you cannot be designated. We don't have to go into designated, do we? Let's see, what are there, 8 of us plus me, I make 9. So let's say you guys all work for my company. All of you work for me. And you're it. You're all, I got 9 people and you are all it. And we have sales meeting on Tuesday. And one of you comes into sales meeting and starts talking about your new listing. And before I know it, next thing I know, you're telling us why your seller has to sell. What you did was you prevented anybody from being designated, right? Because now all of us know the seller's motive. And so if designated ever came up, we couldn't do it because thanks to you for blabbing, none of us can be designated. So in that case, designate is not an option. We would have to remain in dual because you ruined it for the rest of us. Thanks so much. This goes back to, we can talk about the property all day long. Be very careful talking about the people. If you run around and blab your client's information, maybe water cooler gossip, maybe you have a friend in the office and you guys go out for lunch and you're like, oh man, I got this challenging seller and they da-da-da-da-da-da. What you just did to your really good friend was ruin their chances of being designated. Aren't you a good friend? So be very careful. The only person you should be talking to the people about, the only person you should be talking about the people, there we go, is your broker in charge or whoever is appointed to you. Does that make sense? BICs can be designated if they don't have prior confidential information. Some BICs have a policy to never be designated because if the BIC knows anything, they can't. Designated dual agency is a form of dual agency. So as we've been saying, I can't have designated if we don't first have a yes to dual. We have to have both parties say yes to dual before we can be designated. And as you're designated, when you're designated, your only obligation is to the person that you've been designated with. Again, it's now an exclusive. Once you're kicked off the wall, it's now an exclusive relationship. It's the firm that owes all the duties to both parties. Does that make sense? Once you're designated, you're allowed to work exclusively with this buyer or this seller. And as we said, just because you're in dual or designated doesn't matter. That still doesn't give you the right to run around blabbing confidential information. We still have a right to keep our clients' confidential information confidential. There are two caveats to designated. First, you can't be designated if you've received prior confidential information about the other party. So again, if you're working with the buyer, you've been with the buyer for years and years, and then all of a sudden they want, not years and years, months and months, maybe weeks and weeks. How's that sound? And you want to be designated and you know anything about the seller. If you say, yeah, I know anything, doesn't matter how you learn it. If you know anything confidential about the seller, then you can't be designated. The BIC has a choice. They either find somebody else to designate or they have you guys proceed in dual. The other big caveat, and the one that's the problem topic all day, every day, the broker in charge, the designated broker in charge can't be designated with a provisional broker. Any other combination of relationship is allowed as long as we don't have prior confidential information about the other party. But the very nature of the relationship between the broker in charge and the provisional broker, the BIC should be in your back pocket as a PB. The BIC may have gone with you to the listing appointment. The BIC might have been sitting there when you did your buyer consultation. So just because of the very nature of their relationship, the BIC and the PB can never be designated opposite of each other. Can the BIC and PB be in dual together? Can the BIC and the PB be in dual? Now we're processing. I'm seeing heads bob, yes, and you're absolutely correct. The only thing not allowed is for them to be designated. And again, any other relationship is allowed. BIC and broker, broker and broker, broker and PB, PB and PB. Any other relationship is allowed as long as they don't have prior confidential information about the other. Guess I'll see him in about 10 years in my pre-licensing class, huh? Questions, designated or dual? So now what we're going to do, before we get into that, let's go back to our agency agreement. We're not going to look at both. Let's just pick one. Buyer agency is right here. As we noted yesterday, and the day before, whenever, dual agency is discussed both in our buyer agency agreement and in our listing agreement. Once again, you guys, let the forms help you put words in your mouth. So now that we've talked about it, let's go back and see what our agency agreements say. They pretty much say the same. It's just the one says buyer and the other one says seller. So this one says, buyer understands the potential for dual agency will arise if the buyer becomes interested in viewing property listed with the firm. The firm may represent more than one party in the same transaction only with the knowledge and informed consent of all parties for whom the firm acts. So only with knowledge and only with informed consent. Are we good on the difference in consent and informed consent? We got to discuss it. We got to explain them. Disclosure of information. In the event firm serves as a dual agent, buyer agrees that without permission from the party about whom the information pertains, firm shall not disclose the other party the following information: that a party may agree to a price, term, or any other condition of the sale, the motivation of a party for engaging in the transaction, unless it's required by rule or statute, and any information about a party with which the party is identified as confidential, unless disclosure is otherwise required by statute or rule. So again, no golden ticket to run around blabbing confidential information. The firm's role as the dual agent. If the firm serves as an agent for both buyer and seller in a transaction, firm shall make every reasonable effort to represent buyer and seller in a balanced and fair manner. Firm shall also make every reasonable effort to encourage and effect communication and negotiation between buyer and seller. Buyer understands and acknowledges that Prior to the time of dual agency, firm is acting as a buyer's agent. In its separate representation of firm and seller, firm may obtain information which, if disclosed, could harm the bargaining position of the party involved, providing such information to firm. Firm is required by law to disclose to buyer and seller any known or reasonably ascertainable material facts. Always disclose material facts. Buyer agrees firm shall not be liable to buyer for disclosing material facts required by law to be disclosed and refusing or failing to disclose other information the law does not require to be disclosed, which could harm or compromise one party's bargaining position, but could benefit the other. So we're not disclosing, we're not advocating, we're not offering advice. Buyer's role, should the firm become a dual agent, buyer understands and acknowledges that buyer has the responsibility of making buyer's own decisions as to the terms to be included in any purchase and sale agreement with the seller client of the firm. Buyer is fully aware of and understands the implications and consequences of firm's dual agency role as expressed herein to provide balanced and fair representation of buyer and seller and to encourage and effect communication between them rather than an advocate or exclusive agent or representative. Buyer has determined that the benefits of dual agency outweigh any disadvantages or adverse consequences. And buyer may seek independent legal counsel to assist buyer with the negotiation and preparation of a purchase and sale agreement or with any matter relating to the transaction, which is the subject matter of a purchase and sale agreement. Should the firm become a dual agent, buyer waives all claims, damages, losses, expenses, or liabilities other than for violations of the North Carolina license law and intentional wrongful acts arising from firm's role as the dual agent. Buyer shall have a duty to protect buyer's own interest and should read any purchase and sale agreement carefully to ensure that it accurately sets forth the terms in which the buyer included in said agreement. Then, as we saw earlier, we have buyer either authorizes the firm to act as a dual agent or buyer does not authorize the firm to act as a dual agent. If the buyer does not authorize the firm, the remainder of this paragraph shall not apply. So if we say no, designate is not an option. So if we want to do designated, we got to get the buyer to initial and agree to dual. And once they agree to dual, then we discuss designated. Buyer authorizes the firm to designate an individual agent to represent the buyer to the exclusion of other agents associated with the firm. The individual agent shall represent only the interests of the buyer to the extent permitted by law. When dual agency arises, an individual agent shall not practice designated and shall remain a dual if the individual agent has actually received confidential information concerning a seller client of the firm in connection with the transaction. Questions? We got the forms. Remember also, we looked at, back up here in unit or section 1, we got our nice Q&A brochure. This also addresses dual agency. What's the risk of dual agency? What happens if I want dual agency? How do I reduce the risk of dual agency? So we got our agency agreement. We got the Q&A brochure for the working with real estate agents. We have several different resources available to us to help us better understand it, help us better grasp it, and explain it to the public. There's no reason for you guys to recreate the wheel. The information is here for us to use. So don't try to put dual agency in your own words. Use the information that's been provided to you so you can best explain it. Q&A brochure, agency agreements. The last thing I want to point out to you in the Real Estate Commission's website, ncrec.gov, if you go to publications, if you click on update topics, and then we view online, you have, these are from CE, from past CE classes. So if there's material that you're interested in more about, they post 2021, 2022 will be available after June 10th, after everybody's taken CE. So if you need more information, you have the update classes. I mean, you guys, fair housing, material facts again, agency issues. We're going to talk about dual and designated in here, property management. A lot of these stuff, this stuff that we talk about pre and post pops up in a CE class every once in a while, because the commission feels that maybe if it's been a while since you did pre and post, maybe you need a refresher. I mean, we just did agency issues again in 2018, 2019. So yet another resource for you guys to have here. I wouldn't be surprised if we don't see agency again soon, because agency mishandling material facts has been a common complaint at the commission. And a lot of times our CE classes are written based off what is our phone ringing over? What are we getting the complaints? So if they're getting complaints about agency and mishandling material facts, expect to see it in soon CE class. So you have that. Questions or comments? Designated or dual agency? Section 5 is property management. Anybody thinking about considering? Not even a little bit. Okay, it's tough. Well, we were talking about that before class today. It's tough. Property management can be difficult. So some firms just do property management. Some firms will do for sale and property management. Again, it's however the firm set up and whatever their policy will allow. Property management is pretty much in chapter 17. So if you just want to make a note to bookmark that, obviously we're not going through everything in chapter 17, just highlighting a few things. Our license, we just get one license in this state. And our license allows us to do sales, property management, residential, commercial. We can be involved in any transaction as long as the property is located in the state of North Carolina. It doesn't matter where you're standing. It matters where the property is located. And we just have one license. So that license you got, if you want to switch gears to property management one day, you can. Property management requires additional training and education. I think, to be fair, everything does. Residential sales, commercial, no matter what avenue you're going, additional information, education is required. And even if you're acting as a property manager and not a sales, residential sales, license law and commission rule does apply, LLCR, license law and commission rule. Even if the real estate commission says, even if you decide to handle one property management transaction, just one, you're going to do it for a friend or a family member, you are held to the same standards as the agent that manages 150 property management transactions. So if you agree to do one, you're held to the exact same standards as anybody else. Remember, the real estate commission can't fine you, can't sue you, but the injured party can. And that does apply in a property management. All they can do is regulate your license. Licensing requirements in this state. Any individual who agrees in this case to manage a rental property for others for compensation, you have to have an active real estate license. And I think the thing that trips us up is compensation. Typically, compensation is money. But we need to remember compensation is anything of value. So if you're managing somebody's property in exchange for anything of value, it doesn't have to be money. What do you consider valuable? If you're managing somebody's property in exchange for anything of value, you're acting as a property manager. Doing it for others, if you're managing a property that you own, you are the owner of record, you are on the deed, then you don't need a license, right? Because you're doing it for yourself. Even if you have a future interest in the property, let's say you are listed in your parents' will, and when something happens to them, you're going to get the property. My question to you is your name on the deed today? No, your name's not on the deed yet, is it? So even if you're doing it for your parents and you're going to inherit the property, it's still not yours today. So you would still be doing it for others today. Managing property for others for compensation. All three activities are required to have a license. Again, compensation, anything of value. I'll give you free McDonald's once a week, every week for the next 2 years that you manage that property. Is that something of value? Heck yeah, especially if you don't like McDonald's, negotiate that and get you some Burger King or something, right? But you guys with me? It's not necessarily money, form of money, it's some sort of compensation.
So it could be like for rent, like
Free rent is something of value, isn't it? Absolutely. So let's say somebody has a quadplex and they say, all right, I'll let you live in one unit rent free. All you have to do is manage the other 3 units. Are you managing property for somebody for compensation? Absolutely. Thus you have to have a license. Free rent, especially in this market, free rent, absolutely. Magdalene's going to hold out for Chick-fil-A. I hear you. Good for you. You guys get it? What do you think is valuable? 5 goats, whatever you consider valuable, that's compensation. It's not uncommon for property managers to have unlicensed staff. Unlicensed employees can do more for rent than what they can do for sale. Okay, so if you have an unlicensed employee in a for sale situation, they're more limited. Nobody unlicensed can negotiate on behalf of somebody. Nobody with a license can act like an agent. Yeah, right. In this market, in this world. Probably the biggest difference between for sale and for rent unlicensed staff, the unlicensed employee can show property for rent. The unlicensed employee can show property for rent. They cannot show property for sale. Have you guys ever tried to rent an apartment and you go to the complex and the lady puts you in the golf cart and drives you around? That person probably doesn't have a license. Don't know for sure. There's also some provisions with property management. Maybe you're not a property management, but maybe you're a member of the HOA in which you live. Management of an HOA or property owners association is not required to have a real estate license. They're not required to follow the same rules. They're not required to have a license. Thus, they're not held accountable by license law and commission rule. But even though you're unlicensed, member of the HOA, if you're serving as treasurer this year, you could still be held accountable for handling somebody else's funds. So they just point this out. You don't have to have a property manager managing your HOA. Sometimes we all take turns in the HOA, right? Like one year I'm going to be president, you're going to be vice president, somebody else is going to be treasurer, then we switch. Those people aren't required to have a license, but they are accountable for other people's money.
Julie, I got a question. I'm a little confused. Was it when we were talking about commercial where the entity, if it's a W-2 worker of the entity, they could pretty much do everything?
So like we talked about our unlicensed, well, you talked in pre-licensing about your unlicensed. So if you're an employee of a firm and you're managing properties owned by the firm, then you have a little bit, because you're doing it for your employee that's doing it for themselves, right? So you have a little bit of leeway there because the firm owns the property.
Oh, okay. If the firm owns the property, right?
So when we talk about you got to own the property, it's either the individual owns the property or the property owned by the firm. So if you work for that firm, yeah, you can get away with more because you're not doing it for others,
Okay.
right? You're
Then,
doing
yeah,
it on behalf of your firm. That's right.
yeah. And that was like the timeshare type of thing. Yeah. When
Possibly.
that
Yeah,
conversation
depends on who that owner is.
owner is.
Yep.
Okay. Thank you.
I think specifically in pre-licensing, we mentioned and employees of public housing programs managing properties owned by public housing. That's the thing. Does the firm own it or is it owned by somebody else? And that's what we mean by for others.
Okay. No, it was actually, I think it was in my 303 class because I
Okay.
just had that that information it's
Okay.
just fresh on my mind.
Yep.
So it must be my 303 class.
Yep.
Okay.
So
Thank
it
you.
all comes back to whose name is on the deed, right? If the firm's name is on the deed and you're employed by that firm, you're working on behalf of that firm that owns the property. So you wouldn't need a license. They wouldn't need a license.
Thank you.
Yep. Our property management relationships are also regulated by the law of agency. They're regulated by license law. When the agent or the firm is hired by the owner to manage their property, we owe that owner OLCAR. We're entering into an agency agreement. And we owe that owner OLCAR. They're hiring us to perform a job, to perform a service. Property managers work with customers. Usually in a residential situation, the tenant is unrepresented. But doesn't the property manager do a lot with the tenant? Don't I help you find a suitable apartment, help you sign your lease and collect your security deposit, collect your rent, call you when you're late? The property manager is who the tenant knows to call. Sometimes the tenant may not know who the owner is. The only person they have to call is the property manager. What we need to make sure that we understand is who our loyalty is. As a property manager, my loyalty is to my owner. That's who gets OLCAR. The tenant gets honesty and fairness and the disclosure of material facts. I'm collecting rent because that's what's the best interest for the owner. I'm helping you sign a lease because that's what's in the best interest for the owner. I'm working on behalf of. And as a property manager, I have a little bit more flexibility. I can make decisions. I can do repairs up to whatever agreed upon amount. Think about it. If you hire somebody, let's just say you have a property, an investment property, and you hire somebody to management, and that person calls you 5 times a day. This broke, can I fix it? The tenant moves out, what should I do? Should we go up on rent? What do I do if they don't pay? If they're calling you 5 times, at some point you're going to start wondering, why the heck did I hire this person, right? If I'm handling all these questions anyway, what am I paying them for? So just the very nature of the relationship, the property manager has more decision-making authority and ability than the sales agent. How much decision-making authority? That's in our property management agreement. Do your head one way or another. Is working with real estate agent required for lease transactions? Lease transactions. And I'm seeing head shake no, and you're correct. Working with real estate is only required for sales transactions. I do know of property management companies that have their own disclosure. That's their choice, their firm policy. The commission doesn't require this. The firm may choose to have it just to protect themselves. Let all future tenants know, I don't owe you anything, including confidentiality. So they may have an attorney draft up their own. Our property management agreement, again, a property manager is working with the owner. And any agency agreement we have with the owner has to be in writing from the onset. I don't care if the owner is for sale or for rent. I cannot provide a single service for an owner without having a written agency agreement up front The terms apply. We have a termination date. We have our non-discrimination clause. We have the agent's signature, the agent's license number, all that's the same. The one big difference in the property management agreement versus our listing and our buyer's agency agreement and property management, we have a termination date, but we may allow for an automatic renewal. If we have a property management agreement for a year, and after that year, we learn that we're good together. I get you paid, I keep a tenant in place. I'm not calling you and bothering you all the time. I'm providing you the reports. We may decide to continue that relationship for another year or another year or another year. So it is allowed for automatic renewal. Various functions of a property management. Again, this is much more detail in chapter 17. So we're going to go through this pretty quickly. And again, since none of you are going into property management, so we're just going to do what we need to do. One of the functions of the property manager, they need to prepare a management plan. Make sure that they understand the owner's expectations. What are the owner's goals? And what's my plan to help the owner achieve those goals? You guys remember the owner is an investor. And an investor's job is to do what? Make money. So what am I going to do as your property manager to help put money in your pocket? Owners got it made in this case, don't they? I call it mailbox money. Y'all know what mailbox money is? You walk out to your mailbox once a month and you get your money. That's great money. And if you can own several investment properties and have your mailbox money and all you got to do is walk out to your mail, that's not doing bad. Now you got to pay somebody, right? If you don't want to do it yourself. Help the owner establish a rental schedule. Rent's going up right now as we speak. If you didn't sign a lease today, rent may be more expensive tomorrow, yes? Property managers have to keep the owners in tune of what's going on in the market. Is the rental market going to shift somewhere down the road and we start seeing rents come back down? Probably. Rental market is as fluid and fluctuating as the sales market, and the property manager has to keep the owner abreast on those topics. The property manager is going to help the owner prepare an operating budget. Operating budget. Budgets look in advance. So for example, if you sit down on January 1st every year and do your household budget, you're budgeting for things that are going to happen this year. How are we going to afford to take a vacation, have Christmas, birthday celebrations? You're setting a budget for your family on how we can do stuff this year. Operating budget, the owner and the property manager sitting down thinking about any repairs we need to make. I have no way of knowing if the hot water heater is going to blow up this year, but don't I want some money set aside for just in case it does? In the event it does blow up, don't we want to reserve? How can we budget for known and unknown things? When the tenant moves out, the property manager is going to market and rent the property. Let's get another tenant in here. If we don't have a tenant in here, nobody's making money. I'm not making money. The owner's not making money. Nobody's happy, right? So how do we make money? We get a tenant in there. We market the property. We get a tenant to collect rent. So we're going to assist the owner in collecting rent, managing the security deposit. Property managers are required to have a trust account. Licensed, let me rephrase that. Licensed property managers are required to have a trust account. If you're an unlicensed landlord, you can have security deposit in a trust account or a bond. But once you get licensed, property management is trust account only. Bond is not an option. If you're creating a trust account or if you're having one transferred to you, there's a new rule in place. It says you have to take the Real Estate Commission's trust account course within, I think it's within 120 days of taking on the trust account. So they have a 4 or 5 hour class. You do get CE credit for it. So there's 2 birds, 1 stone, CE elective credit. But if you're managing or opening a trust account as a licensee, You're required to take their trust account course, so you know how to properly manage that. The property manager is going to help the owner maintain and protect the property. Again, repairs, we got to discuss how we're going to do repairs. When are we going to do repairs? When are we going to upgrade the kitchen? What are we going to do when the tenant moves out to get it ready for the next tenant? If the property's in an HOA, the property manager needs to make sure that the tenant is aware of the rules and regulations. If there's a violation of the HOA isn't going to call the tenant. The HOA isn't going to call the property manager. They're going to call who? They're going to call the owner of record, because that's who they know, right? Is your owner happy if they get a call from the HOA saying that the tenant violated the rules and regulations? No. So that's the job of the property managers, make sure that the tenant is aware of the rules. The property manager is acting as an extension of the owner. So in a sense, both parties are acting as the landlord. The property manager should manage this property as if it's their own, because they are an extension of the owner. So know what we're clear on the lease, what our duties and obligations to each other are under the lease. If your tenant skips out in the middle of the night or refuses to pay, you got a squatter on your hand. We're going to assist the owner in handling, instituting legal actions. I have an acquaintance, this poor girl, she works for a property management company. One day every month, one day a month, she spends at the courthouse doing her summary judgments. One day every month, that's what she does. Does that not just seem like a long, she just pretty much sits and waits in line so she can file her summary judgments to get the tenants removed on behalf of her property manager. Dang, what a day. Once a month. That's 12 times a year, by the way. That's a long day. So instituting legal actions. The property, okay, the owner is ultimately responsible for maintaining property insurance, right? The policy's on the owner's policy. The tenant should have renter's insurance, but the owner's going to have homeowner's insurance. The property manager can make payments on behalf of the owner. They can revisit or renew policies with the owner's request. So understand that ultimately the responsibility of property insurance is on the owner. The property manager may assist, but ultimately it's the owner's name on the policy. They're the ones ultimately responsible. They may assist. And then we're maintaining, the property manager is maintaining records and accounting, accountability to the owner. I am watching my time. We're taking a break in just 1 second. Bear with me. Not lunch, just a break. Rattled off a whole bunch of things that the property manager can do. It's important that we also address what they can't do. The property manager cannot reinvest the owner's profits. It's not my money to handle. It's not my money to say, should you put some money aside to upgrade the kitchen next year? I can't answer that for you. I can tell you what our rental schedule will look like if we do have an upgraded kitchen, but I can't force you to reinvest. What if the owner never wants to set money aside? What if they want their mailbox money for them to spend on their own? I can't tell them what to do with their money. The property manager also can't file or pay property taxes on behalf of the owner. Again, the owner is the owner of record, so they're the ones that are responsible for maintaining and paying those property taxes. Anybody gonna change your mind yet and become a property manager? Did that do it? No, okay. Just thought I'd ask. Magdalene's still shaking her head. Absolutely not, Julie. Not even a little bit. I hear you. Questions on the property manager? Short and sweet and to the point. All right, let's take a break. When we come back, we got one more little section to cover. This is our everything else. So license status, education, that kind of thing. We'll get through that pretty quickly. And then we'll talk about what the rest of the day looks like. So let's take 10. I got 12:02. Let's come back at 12:12. And we're close to wrapping it up. We're getting there. My husband just said, I'm going to Bojangles. You want anything? The answer to that question is always yes. It's not Chick-fil-A, I know, but
Well, my husband's choice was Chipotle today, so even better.
ah, there you go. There you go. Husbands are good sometimes. Most times. All right. Last thing on property management. Just so you know, we do have a property manager agreement, exclusive property management agreement. We're not going to go through this. I just need to know that you guys know it's here. It's a standard form provided by NCAR. This creates the relationship between the property manager and the owner. And remember, this is an agency agreement. So this is an employment contract. The owner is hiring the agent to manage their property. The agent owes the owner OCAR. The only thing different, the big difference is that this does allow for an automatic renewal if the parties agree. Questions on property management? The last little section we have is this other, falls under the category of other. So we got a couple specific things in other to address. First off, let's talk about when the broker leaves or changes the company. If you leave your company, can you still be paid commission on a pending transaction? So you put something under contract and you leave. Can you still get paid? The answer is yes, because the firm, you've brokeraged the majority of the deal. You can't take it with you because it's the firm's contract, but the firm may still pay you if you leave. The commission allows it. It may come down to firm policy. Again, before you sign that contract to affiliate with a firm, make sure you know what happens when you leave, if you leave. A broker with a current active license throughout the period in which brokerage services were performed may legally be paid by the company, even if the broker is no longer associated, or if the broker's license is inactive or expired at the time of the payment. So what if you don't change firms? What if you forget to renew? You brokerage the majority of the deal. You wake up on July 1st and realize your license is either expired or inactive because you didn't do your education or you didn't pay your fee. We'll talk about that a little bit more in just a second. The commission allows you to be paid on an inactive license or an expired license if you brokerage the majority of the deal while you had an active license. And as soon as your license goes inactive or expired, you stop. Once you're inactive or expired, you can't finish it. The commission allows it. It's up to the firm's policy if they'll do it or not. So let's say you don't pay your renewal fee. You wake up on July 1st and your license is expired. Closing is scheduled for July 2nd. Can you go to closing on July 2nd? No, because you have an expired license. So your BIC would have to go to closing for you. You guys with me? As soon as your license stops being active, you've got to stop. So as long as you brokerage the majority of the deal and you stop when you don't have an active license, the commission allows you to still get paid. It's up to firm's policy. We have a duty to notify the commission in writing anytime we change our name, address, phone number, email address, anytime we change our contact information. Who remembers how many days within the change we have to change our information? Yep. 10 days from the change. When you change firms, make sure that notification gets down to the commission. A lot of times your firm and your BIC will handle that for you, but make sure that gets down to the commission. If you move, personal residence, if you change your email or your phone number. Now that you guys are all licensed, you have a back end login to the on the Real Estate Commission's website. On the home page, you have a licensee login. Your licensee login is your license number and the last 4 digits of your social, unless you change that. That licensee login is where you can go to change your information. So if you change your name, if you get married or divorced and you change your name, if you change your address, phone number, whatever. I was impressed. I got my license hanging up here. When I got married, they sent me a new license. I didn't know that they would or not, but they did. They sent me a new license with my new name. I thought that was kind of cool. Same date as when I was initially licensed, but they sent me a new license. So they recognize that. 10 days to change. What happens to your active listing if you leave a company? The answer to that is it depends, doesn't it? It's up to the firm's policy. Remember, whose listing is it? It's the firm's. So when you leave, whether or not you can take it, they have to release it. If their policy allows, I mean, I'd like to think if I had mom and dad's house listed and I leave, the firm will let me take my parents' listing. You know what I'm saying? But this is another reason to make sure you check firm policy, because some firms may not release their listing. If you're a member of NAR, remember Code of Ethics says you cannot solicit an active listing of another company. So you have a listing with firm A, you leave to go to firm B. Can you solicit your listing from firm A? Not according to the Code of Ethics. We cannot solicit another firm or broker's active listing. Again, you guys, it all comes down to company policy, firm policy. Read that independent contract agreement before you join. Make sure you know what happens if and when you leave. You guys promised me that? Fair enough? Real Estate Commission doesn't get involved with matters of money. Commission doesn't get involved with commission. If you get paid, how you get paid, it's not up to the commission. It's up to the firm's policy. Can you take your listing? Commission's not going to dictate that. Can you still get a referral fee? The commission is not going to dictate that. It's all up to the firm's policy. Provisional brokers, if you guys leave a company, if your license goes inactive or expired, your firm or form has a choice on how they can pay you, if they're going to pay you. They can either pay you directly because you are affiliated with them for the brokerage services, or they may choose to pay your new company and have your new company pay you. So as a provisional broker, if you're going to get paid if you leave or you lose your license. Obviously, if your license goes inactive or expired, you don't have a new company to pay, right? So in this case, they would have to pay you directly. But if you change companies, they may pay you again, because the brokerage services was done when you were with firm A. When you leave, if you leave a company with a pending transaction, pretty much as a provisional broker, you got to leave it behind. And the reason being for this is because BPs can't be dual affiliated. BPs can only be affiliated with one broker. A broker could be dual affiliated. So the old firm may ask you to keep your license there until this transaction closes. So you might be dual affiliated until all your business is done there. Does that make sense? Remember, you as a broker, you can be dual affiliated. You just have to have consent of both firms. Some agents try to think, well, I'm going to get everything closed out before I leave. The problem with that is all the coachers, all the trainers, everybody out there tells you to keep feeding that pipeline. keep business going. Because once you have everything in your realm closes, you have nothing else in the pipeline, right? So now you got to change companies and basically start all over trying to get business. So at some point, you're going to have to, if you choose to leave, you're going to have to make that cut. You may lose business, you may not. Some agents move around a lot. Sometimes we say don't get too used to your peers because they're going to be somewhere else. Some agents firm hop. Some agents are pretty committed. They'll stay. Just remember, we're independent contractors. We're not employees. Questions on that? The last little piece in this other is licensing and education. Again, you see this in every post you take. Newsflash, you're going to see it every year in CE too. There's a reason why they keep reminding us about licensing and education. A lot of agents out there don't understand their license status, their licensing. So there's a reason why they keep at us on it. Let's talk about license status. An active license is current and your education is up to date. When you guys see the word current, I want you to see the word currency. Is it E-A-N-C-Y or E-N-C? Currency. You guys know what that says. So when you see the word current, I want you to see currency. Your license is current because you pay the fee every year. The Real Estate Commission's physical year is July 1st to June 30th. The Real Estate Commission doesn't operate on a calendar year. They operate on a physical year. Our renewal period is May 15th to June 30th every single year. This means we are a little over a month away from having to renew our license. And we renew our licenses by paying the fee. You'll get a letter, you'll get an email, your BIC will bug you. You'll know that it's time to pay. The last several years, it's been $45. I don't know what this year is going to be, but we can guess about $45. So even if it's your first year and you don't have to take CE this year, I'll talk about that in just a second, you still have to pay the fee. Always pay the fee. Paying the fee keeps your license current. Take it a step further and do your education. May that be CE and or post licensing, depending on where you are. We'll talk about both in just a second. Inactive status is the only status in which we can get paid and market our services in any way. I can't hand out a business card if my license is not active. Of course, we just talked about the exception, unless you brokerage the majority of the deal before your license goes inactive and the firm allows. So an active license is current, you've paid the fee, and your education is up to date. An inactive license is also current. Current means what? Current means you have shown them the money, you've paid the fee. Several of you on this call right now are inactive. We'll talk about how you be inactive in just a second. You're current, but you're either delinquent on your education, you're a PB without a BIC. An inactive license, you cannot engage in any activities requiring a license. You can't expect to be paid a referral fee, compensation, bonuses. You can't hand out a business card. You can't promote your services. So paying the fee means your license is active or inactive. We'll talk about what happens if you don't pay the fee in just a second. To have everybody so far, a current license is either active or inactive. How do you keep it current? Pay the fee. You can be inactive. You're a PB without a BIC. A couple of you are in that scenario right now. If you're not affiliated with a firm, you're inactive. Part of your application fee when you apply for your state exam was keeping your license current, your new license current. If you pay the fee but fail to do CE, then your license is inactive. You paid the fee, so it's current, but you didn't do CE. Or you didn't do your post licensing within 18 months. As long as you pay the fee, you can maintain an inactive license until you get caught up on your education. So if you missed your 18 months for post licensing, you can't activate until you get that done. If you don't do CE, you can't activate until you get caught up on your CE. You could also choose to be inactive by choice. You could ride the rest of your life on an inactive license. All you have to do is pay that fee. Send in your $45 every year, and you can go forever and ever and ever on an inactive license. Maybe you do CE, maybe you don't. Failure to pay the fee means when you wake up on July 1st, your license is expired. We have until 11:59 p.m. on June 30th to pay the fee. I'm so proud of the commission. Within the last 4 or 5 years, they've gone online. We're no longer mailing checks in. Seemed like it took us a minute to jump on that bandwagon, but now we can go straight to our licensee login and pay our fee directly. It's never been easier. That window opens on May 15th. You can't pay the fee until May 15th. You have a window of 45 days to pay $45. Hey, how about that? May 15th to June 30th. An expired license is not current. I don't care if you've done CE or not. An expired license has nothing to do with education. It has everything to do with paying that fee. Do I have everybody? Current or expired, pay the fee or not. If you want to reinstate an expired license, it depends on how long your license is expired before you reinstate it. So if you're expired within 6 months, you wake up on July 1st and go, holy crow, I forgot to pay my fee. You pay the reinstatement fee and you pay the renewal fee. So you're paying the fee times 2. 45 times 2 means you got to pay $90. You submit the form, you're back on track. If you're expired for more than 6 months, but not quite 2 years, you pay 2 times the fee, renewal fee and reinstatement fee. You come back and see us and retake 1 post licensing class. At least it's of your choosing. Or you go back to PSI Testing Center and retake both portions of the state exam again. Which would you rather do? 1 post or PSI? I can't answer that for you. I think we're all pretty much on the same board. But you have to complete that post before they will reinstate you, pay the fees, reinstate you. Does anybody know the horror? What can happen when you're expired for more than 2 years? This is bad. This one hurts.
You're starting all over again.
You are starting all over. You're coming back to my pre-licensing class. If you're expired for more than 2 years, guys, this happens more than you think. Agents think they're done with real estate. We come to a fork in the road and we choose to go the route other than real estate. Maybe you're starting a family, maybe you're caring for elderly parents, right? Life happens, stuff comes up. And so you choose to let your license go. Fast forward 3 years, 10 years from now, and you wake up and say, I want to be an agent again. And you call the commission and say, hey, y'all remember me from 10 years ago? What do I need to do? And the commission's going to say, start all over. The last in-person, no, this is in-person, the last face-to-face class I taught, pre-licensing class I taught before we shut down, I had 2 people that were there because they were on an expired license for more than 2 years. So this happens. I see y'all are so cute. Like, not me. Good. Even if you think you're done with real estate, I think it's best to send the fee in every year. Again, I cannot make that decision for you, but even if you think you're done, I think it's best to send that 45 bucks in. You may have to get caught up on post. You may have to get caught up on CE, right? You may have to do some education. So you have a choice. You either send in the 45 bucks and do some education, or you save the 45 bucks and you do all of the education. You start all over. Kiana didn't like that either. I know. I said, hey, y'all made it this far. Y'all got your license. Do everything you can to keep it. Y'all worked hard for that little piece of paper, didn't you? So do what you can to keep it. I'd rather do a transaction with you guys or see you in CE than see you again in pre-licensing. Fair enough? But if I do see you again in pre, you're welcome, of course, with open arms. We'll get you through it again. Questions on your status, current or expired? There's two statuses, current or expired. A current license can be active or inactive. You want to be active? Pay the fee and do your CE. See how that rhymes and everything? That's all you got to do. Fee and CE. You guys, I call you guys my brokers with training wheels. You can't yet ride your bike on your own. You're close. Some of you are closer than others. John's on his third one. Who else is on their third post? Magdalene, is this your third one? Abigail, this is her third one. So several of you are close to losing your training wheels. Removal of your provisional status means you've completed the 90 hours post-licensing. Once you complete the 90 hours, then you're a full broker. The definition of a full broker is a broker that's completed post-licensing. So that's how you remove your training wheels. You guys watch that 18 months. We were talking again before class, that time's easy to get away from you, especially if you affiliate. The real estate commission is not going to call you or send you an email and say, hey, Julie, you've been at it for 17 and a half months now. Don't forget to do your post. That's on you to keep up with that time. Look at your license and there's a date on your license. Your 18-month clock starts on that date. So if you're not done, if this isn't your last one, just don't let it get away from you. And in addition, your training wheels is your BIC, the firm that you're affiliated with. So as a provisional broker, if you want an active license, you have to affiliate with a BIC. As a PB, if you're not affiliated with a BIC, then you're inactive.
Julie, your CE has to be completed by what, June 15th?
We're getting there.
Okay, cool.
Yep. Hang on. So PBs have to complete post-licensing within 18 months. The good news for provisional brokers, you don't have to do CE your first renewal period. So whatever date you got your license, the first time you hit May 15th, you don't have to do CE that year. You have to pay the fee. Always pay the fee. When in doubt, pay the fee. If they don't need it, they'll send it back. It's not going to happen. But your first renewal period, you don't have to do CE. The thinking is you guys just got out of pre and post, you have the current information. So they do give you that. They give you your first year off. Any year after that you want an active license, you have to do CE. We do 8 hours of CE every year. We do a 4-hour update class. If you're a provisional broker or a full broker, you do the general update, also known as the Gen Up. If you're a broker in charge, you do the broker in charge update, also known as the BIC Up. Make sure you're taking the appropriate CE class. If you're a BIC and you take the Gen Up, you're not going to get credit for it. So make sure you're taking the appropriate update course. And by the way, this is BIC eligible, and designated broker in charge. Both BICs fall under for the BIC up. And in addition to our update course, we also do one elective class, 4 hours of each. The elective is a topic of your choosing. So you can select what update or what elective course you want to take. What do you want to learn more about? What avenue? What's your niche? That's a good opportunity for you not only to get the requirements for CE, but also get yourself some more material. All right, so the question is, what is our deadline for completing CE every single year? The deadline to complete CE every year.
June 10th.
You're late, Donna. Your deadline every year is June 10th, June 10th, June 10th, June 10th. You have got to have CE done by 11:59 on June 10th. Here's the deal. The Real Estate Commission won't allow any school to offer CE from June 11th to June 30th. June 11th to June 30th is known as a blackout period. Every single one of us, all the brokers, all the firms, all the schools, all the instructors, every single one of us is renewing our license from May 15th to June 30th. I have no idea how many schools and instructors are out there. I think the last report I saw, there were like 108,000 licensees, firms, PBs, brokers, everybody, 108,000 licensees that they're processing. In addition to processing our fees, they have to process our education. And that's why they put a cutoff time. That's why they put a cutoff time on CE. My suggestion, y'all do what you want to. My suggestion is not to wait until June 10th to take your CE. Because what if you're doing it online and you wake up this morning and your internet's out? You're out of business on July 1st. What if you're going in person and you wake up this morning and your tire's flat in your car and you can't get there? You're out of business on July 1st. Things happen on June 10th. Yes, things can happen. So my suggestion is to get it done. They usually roll out the new material for CE about fall-ish. So September, October, something like that. You can start taking it as soon as it's available. A lot of agents will tell you that we're slow in the winter time, the winter months. Why in the world are we not taking advantage of CE in the middle of winter? So when the spring rolls around, we're ready for the spring market and we don't have to worry about those 8 hours. Again, if you're a daredevil and you like to live life on the edge, take CE on June 9th. There's no rule that you can't. I'm just suggesting that you get it done so you don't have to worry about it. Questions or comments? So let's walk through a little scenario together real quick. Melanie is a provisional broker. She completes her required 8 hours of CE on April 22nd, but Melanie, she fails to pay the $45 renewal fee by June 30th. She did her CE, but she didn't pay the fee. On July 1st, what is the status of Melanie's license?
It's expired.
That's exactly right. That's exactly right. It's not current because she didn't pay the fee. A current license has everything to do with paying the fee. It has nothing to do with education. So even though she did her CE, where did she go wrong? She didn't pay the fee. Failure to pay the fee means she's expired on July 1st. So yes, she's expired. Can Melanie continue working with clients and customers after July 1st? Nope, she's done, isn't she? Until she can get that fee and reinstatement fee made up. She's got to stop all activity July 1st until she can submit her payment. If she does it on July 1st, she's back up and running. You guys with me? If she's out of town and doesn't have access to the internet, can't do it until July 6th, she's got to wait till then. Let's say Melanie does complete her CE and pays her renewal fee on time. However, as a provisional broker, her BIC fails to renew his license. If Melanie's BIC doesn't have an active license, can Melanie continue working in general brokerage? No, because as a PB to be active, you have to be affiliated not just with any BIC, but also with a BIC with an active license. The firm, the BIC has to maintain active as well. So when your BICs are on you in a few weeks, did you renew? Did you renew? Did you renew? You guys can say, yeah, I renewed, but did you? So you need to make sure that they renew as well, because you renewing as a PB doesn't do any good if your BIC doesn't renew too. Some firms, especially your larger firms, like to have a BIC eligible laying around in case something does happen to your designated BIC. They got somebody else they can just slip in there real quick until we can get this figured out. So the show goes on. Yeah, Magdalene.
If your license expires at any point, if it's renewed, does your license date change, or is it still the original date?
It's still going to be, it should be the original date. It should be the same number. So my two guys in pre-licensing that we encountered this because they couldn't apply as new licensees because they already had a license number. So I'm not exactly sure what happened to their dates, but they were basically applying to reinstate an existing license.
Gotcha. Okay, thank you.
So, and that was something because they asked me, and I believe my answer was, so that was something we had to get with the commission to, you know, find out that we properly handle that. That was news to me too. So yeah, and I'm not sure how their dates were listed. That's a good question, but they did get the original license number. So I'm guessing the date was back to the, I mean, I look at all your license numbers, 33 something, 331, 334, you know, you can tell how long an agent's been licensed just by looking at their license number. Compare you guys' license to mine. This hurts. It always hurts me when I see your license because I compare your license to mine. I've been licensed a lot longer than you guys have, haven't I? I'm getting ready to come up on celebrating that 100,000. That is going to hurt me. I'm just saying, by the way, when I see that. But you can tell by looking at somebody's license number how long, at least they've been licensed. Maybe they're in the business, maybe they're not. But you can tell. Got mine in 08, by the way. So that's how far back that goes. Other questions or comments? So let's talk about what's going to happen. We're getting ready to break for lunch. We're going to log out, go to lunch like we always do. We'll talk time in just a second. One thing I need you guys to do at lunch, you guys look like you're pretty good, but securing a distraction-free place. When we take your exam, I can't have people around you. I can't have people in the room giving you answers, right? So yeah, whomever you were just talking to in the room, I see you. So one thing you can do for lunch is discuss with your family, let them know that when we come back from lunch, we're going to be doing a test and we need you in a distraction-free place. Everybody good with me so far? Okay. So when we come back from lunch, you got a lot going on, don't you? So when we come back from lunch, I got a little exam review for us. We've talked about a lot in the last 2 weekends. I think we can all agree on that. So I've put together a little exam review to help us hone in on important things that we may see again later this afternoon. So we'll do our little review. We'll go through the exam rules and expectations for my exam. You may have taken an exam with another instructor with Carolina School of Real Estate. I may or may not do things differently. So we're going to talk about my rules and expectations. We'll take another break, and then when we come back, we'll be ready to start our exam. So we'll probably be starting about, my best guess is going to be about 3:15 3:30, 3 to 3:30, something like that, which means you guys will get out a little early. So we're going to take lunch. I'm going to put my phone number in the chat. If you have a question that you think of during lunch, feel free to send me a text. So if you're thinking about the exam, thinking about the material, if a question pops in your mind, also during your lunch break, go ahead and grab a couple pieces of scratch paper, blank paper. I will let you have paper. Again, in the rules and expectations, we'll do a little one-on-one check-in process so I can see what you have. I want clear desks, clear space, good clean working area. Remember, you need a calculator. No phones. Your phone has Google on it, so I can't let you use your phone. So get you a calculator, blank paper, and a distraction-free area. We'll do a review. We'll do rules and expectations, and then we'll bust this thing out and take an exam. How's that sound? Very good? All right. I got
Just
12:48.
a heads up, Julie, my space is gonna take a bit because I'm working from my studio and my stuff is hooked up. So in the last class I'm just gonna say it's gonna take me a little bit to take and turn everything around.
I understand.
Okay.
I understand. Yep. Everybody's set up different. So that's why we do a one-on-one check-in process. And again, we'll talk about that after more specifically after our review. Thank you. Okay. All right. Lunch, let's take an hour. We'll come back at 1:50. I'll log on at 1:45. We'll come back at 1:50. You can see here, the very next thing we have to do is a review. So we'll do that when we come back and get ready to take your test. Sound good? Any questions? All right, y'all don't eat too much. I don't want you being sleepy this afternoon. So don't eat too big of a lunch. Don't get jacked up on caffeine either, right? Find your balance. All right. We'll see you guys in an hour.